now in session. Judge Stork presiding.
Good morning, everyone. Please have a seat.
Yeah.
All right, time set for trial in Nelson versus Wade. Let's start with appearances for the record, please. We'll start with the plaintiffs.
Good morning, Your Honor. Paul Friedrich for plaintiff William Nelson. And good morning, Your Honor. For the record, Alexander Sutherland here with Mr. Nelson as well.
All right, thank you. For the defendants?
Good morning, Your Honor. I'm Erin Lane, appearing for the defendant, Houston Wade.
Good morning, Your Honor. Melissa Hulsman. I just appeared to assist Mrs. Lane.
Very well, thank you. All right, so first thing, just a reminder to everyone that all we have to try this morning is the willful prong of Section 523A6, which focuses primarily on Mr. Wade's subjective intent. So as you are presenting evidence, please keep that in mind, and let's not try to stray off into a lot of areas that don't go to that issue, because pretty much everything else in this adversary proceeding, I decided on summary judgment based on preclusion from what happened in the state court. So try to stay focused as best you can on the actual issue that we're trying this morning. Next, at the pretrial conference, we talked about admitting exhibits. You did submit a revised pretrial order, which I entered, which appears to have 6 of the exhibits that the parties have agreed are admissible. So my intention is to go ahead and admit those now unless there is some objection. So, Mr. Friedrich, any objection to the admission of the agreed exhibits in the pretrial order?
No objection, Your Honor. Just to confirm, those exhibits are Plaintiff's Exhibit 1, Plaintiff's Exhibit 4, Plaintiff's Exhibit 5, Plaintiff's Exhibit 7, Defendant's Exhibit 3, and Defendant's Exhibit 6.
Correct. And Ms. Lane, any objection?
No, Your Honor.
All right, then exhibits P1, 4, 5, 7, and D3 and 6 are admitted. As far as testimony, again, we talked at the pretrial conference, we just have the 2 witnesses, but did you talk about the order or how you wanted to present? And what I mean by that is there's really 2 ways to go about it. The plaintiff can present their witnesses and they can cross and then be done, and then the defendant can call the same witnesses and you can do cross and we're done, or else you can just do everything at once, one time with each witness. And I really don't care how you do it, but I'd like to know how you would like to do it. So, Mr. Friedrich, first of all, did you talk about that at all? And if not, do you have a preference on how to go about it?
Your Honor, we did speak with counsel regarding that on Friday, and we thought we had an agreement, but it sounds like there was a little bit of confusion when we met with Ms. Lane this morning. So I probably need a minute to confer to just clarify what exactly are, in fact, our positions on that question, Your Honor.
All right, then I'll give you a minute just as soon as I get through my preliminary things.
Thank you, Your Honor.
Which is the next one. Are there any preliminary things from the parties that we need to cover before we start with the actual presentation of testimony? Mr. Friedrich, anything from you?
Nothing, Your Honor.
All right. Ms. Lane?
Yes, Your Honor. You had on Friday said that if, for example, I'm up questioning a witness, that like Ms. Fieldman could object as well. I'm asking the court to reconsider that. I believe that it could cause a little bit of a circus within the court. I think of whoever is up there asking the questions, that should be the person who should be, I mean, they're the one examining, they should be the ones also to object while they are up there.
Yeah, and again, I kind of waffled on it during the pretrial conference. I said I start that way, but if it does become a circus, I'm going to cut it off. So I'm going to let it see how it plays out, but if we're having any problems, I'm going to tell the parties that's the end, and we're going to just do it the way that you would prefer. But I'm going to let it I'm going to let it at least start that way, and if it becomes a problem, I will stop it. Let's see. I think that's it. Oh, the only other thing, use of the podium for me is optional. I don't require people to get up to the podium, so you can present from wherever you're comfortable. But you do need to be close to a microphone is all when you're talking, because that is our official record. We don't have a in-courtroom court reporter. It's all digital audio. So with that, why don't I give you just a minute to confer about this witness question, and then we'll get started. And for that, maybe just back away from the microphone, actually, if you would.
So honestly,
Yep.
And how are we going to proceed?
Your Honor, the parties have agreed that we will proceed via the first route, where essentially we will call each individual and complete all testimony, cross-examination, and whatnot all at once, and then proceed to the next one rather than have two separate
Okay.
cases in chief. This is being done with understanding that essentially, well, it might go back and forth quite a few times depending on, redirect, considering we are combining the two sides at the same.
What you mean by that is while the witness is up there, each side may
Yes,
question multiple times.
yes.
That's fine. That work, Ms. Lane?
Yes.
All right?
Yeah, I would just add to I think he just forgot that one of the things we talked about was if a witness has already stepped down and the other person's up, but then one of us decides that, or realizes like, hey, we wanted to ask that person another question or something like that, that we would not oppose each other recalling that person for obviously something, limited, not
Yeah.
like 2 more hours of testimony.
Yeah. So, right.
Is that
So
consistent, counsel?
the first person testifies, then the second, and based on the testimony of the second, somebody may want to ask a question again of the first witnesses.
Yeah.
Will allow him to be called back.
Yeah, and I think it was contemplated in a restrained fashion, so it's not opening the floodgates again for hours more, but just like, oh, hey, something came up, or we forgot something, or,
Yeah, understood, and that's what I would expect when we do it this way, so that's fine with the court as well. All right, so let's call a witness, please.
Your Honor, I think we're going to have a very brief opening.
Oh, you want to have an opening? Go ahead.
Yeah, just very briefly, Your Honor.
Yeah, no problem.
I'd be remiss if I didn't give an opening, even though Your Honor said it's optional.
It
Your
is
Honor,
optional.
I'm sorry, before he starts, I
Oh.
thought you were going to rule on motion in limine.
The ones that I didn't already rule on, I'm just going to rule on in the context of in the course of the trial, if they even come up. I've looked at some of these. I don't think some of these are even going to come up, but if they do, I'll just rule on them as live objections during the course of the trial.
The only one that I guess we need clarification on, and obviously I'm new to this, but I've done my best of getting up
Yeah,
to
that's
speed
all right.
on this very quickly, is the admissibility of the deposition transcript that was never disclosed during discovery.
I think we ruled that it's not admissible as an exhibit. We did cover this one, I think.
Okay,
I
I'm
think
sorry.
the transcripts are not admissible as an exhibit, but they can be used for impeachment.
Okay, sorry, sorry. It's hard because I'm talking and she's telling me she didn't understand that. But, sorry, so my question though is, they had a document that they intended all along to use and did not provide it in initial disclosures or anywhere else during discovery. So now essentially they're being rewarded for hiding it, withholding it, and then saying like, oh, hey, we might use it for impeachment, but by the way, we didn't give it to you until the last minute, even though we fully intended to use it.
Well, can't you pull out anything for impeachment? Really, at any time?
Well, that's true, but I don't think a party should be rewarded for violating the civil rules regarding disclosure. I mean, I litigate in federal court, but
Yeah, I
mostly state
understand.
court. State court doesn't have, the broad parameters that federal court does. Federal court, I mean, I knew this anyway, but when I give discovery, I'm like, here's everything. Like, I don't, take it. I don't care. With very limited restrictions. But federal court is all about disclosure, and disclosure up front as soon as possible, even if somebody didn't ask for it, provide it. And they didn't. And so, but I agree with you. Yes, I mean, certainly I've certainly impeached people before with things that I had not disclosed, but it was because somebody lied on the stand in a way that I didn't anticipate. And then I went and got something that dealt with that issue. So.
Well, first of all, I take exception with the characterization that we hid something or that we're trying to take advantage of, the discovery rules or take advantage of any other, of the disclosure rules in the federal rules of civil procedure. This is not a document that was, willfully not disclosed or withheld. This is a document that's been in the debtor's possession for numerous years. And I believe our discovery responses and our initial disclosures are broad enough to encompass and that we would use anything.
All right. That's fine. I mean, you won this objection, so you're okay. Like I
Thank you.
said at the pretrial conference, neither of these deposition transcripts come in as admitted exhibits, but they can be used solely for impeachment. So with that, let's have your opening statement.
Thank
Thank
you
you,
for the
Your Honor.
clarification.
Thank you, Your Honor. I'm going to keep this very brief. we are here to establish at trial the sole and narrow element of the debtor's intent to willfully injure our client, plaintiff, Mr. William Nelson. Unlike the summary judgment proceedings prior, the burden of proof at trial is much different. We are not, the evidence is not going to be reviewed in the light most favorable to Mr. Wade, as in the prior summary judgment proceedings. We need only establish the willful element by a preponderance of the evidence, which means more probably true than not true. The evidence is going to demonstrate by a preponderance of the evidence that the natural consequences of the debtor's actions, i.e. repeatedly publishing false accusations of sexual assault, that he intended to cause injury to Mr. Nelson, or that the natural consequences of publishing a false allegation of sexual assault would lead to injury. We do not need to establish his affirmative intent. We are not going to get an admission in court from the debtor that he intended to injure our client in falsely alleging sexual assault. We only need to establish circumstantial evidence, which tends to establish that he must actually have known when publishing a false allegation of sexual assault that it would lead to injury. Now, we've heard multiple versions and excuses as to why the debtor does not have the requisite intent. We've heard, and I anticipate we will hear, that he was reckless, that he made a foolish mistake, and that is the first excuse. But if this was in fact a reckless one-off mistake, it would not have been a repeated systematic campaign of character assassination, over and over again publishing false allegations of sexual assault and other horrible things about our client. And any attempt to divorce the act from the intent is nearly impossible, given the allegations that we're talking about. I mean, these are not just innocent false accusations. I mean, these are the most horrific, heinous, vile accusations that one can level against another human, particularly in this day and age of social media, where the spread is so pervasive, and especially in a small community like Bainbridge Island. So this is not a situation where the debtor made a one-off mistake. This, again, was a systematic campaign of character assassination leveled at our client. And the evidence will establish that the debtor must have known the natural consequences of his action, that this would lead to injury. Again, we're not required to establish or get an admission in court that he intended to cause this injury. The law says that the circumstantial evidence surrounding the acts themselves can be self-evidencing. And that is what we will establish here today. Thank you, Your Honor.
All right, thank you. Ms. Lang, would you like?
We have one simple issue today to prove, and that is, did Mr. Wade intend to cause the injuries that Mr. Nelson sustained? And the simple answer is no. The evidence will show that his intent remained throughout the state and this court, that his intent was simply to warn, to protect, not to cause injury to Mr. Nelson. You cannot simply say, I have these injuries, it was because of what you said. They have to prove that my client had the actual intent to cause those specific injuries. And the evidence will show that he did not.
All right, now we'll take a witness.
Thank you, Your Honor. We'd like to call Mr. Nelson.
All right. Come right up here, Mr. Nelson, please. solemnly swear or affirm that the testimony you'll give today will be the truth and nothing but the truth? All right, thank you. Please have a seat.
And Your Honor, before we begin, a quick clarification in terms of how the court would like to proceed regarding exhibits. Would the court like us to be using copies that we have in our possession, or?
He'll have exhibit notebooks if they're not, are they there?
Okay. I
Do you have
wasn't
two
sure. so-
notebooks with you? Yeah, he's got his own set, so you just need to
Fantastic. That's what I
refer.
would want to ask. Okay. Thank you very much, Your Honor.
Yep. I'm ready when you are.
Thank you. Mr. Nelson, please state your name and spell your last name for the record.
William Peter Nelson, Nelson.
Thank you. And where do you live?
I live on Bainbridge Island,
Could you describe for the court that, Bainbridge Island?
small island, about 25,000 residents. I was born and raised there, fourth generation, for 64 years of my life.
Okay. And what do you do for a living?
I'm a building contractor, design, build, construction company that's been in business for 40 years on Bainbridge.
Bainbridge Island is the targeted consumer base?
It is.
How did you first learn about the post from Mr. Wade?
A friend of mine that follows Facebook brought it to my attention. It was shocking, disturbing, revolting, disparaging. I didn't understand where it was coming from or why.
And what did the post say about you?
Primarily, it started with a large sign of a development sign that I had in 2007. I think it was probably harvested from the local newspaper, showing me holding a sign, damning me with these allegations of rape, child abuse, malicious intent with other people. It was across the board embarrassing, detrimental, destructive.
Where was this posted?
It was posted on the Facebook page of Houston Wade's and on what he called the bad list of Bainbridge Island.
And these were both on Facebook?
Yes.
Okay. Were you able to find any other posts?
He posted on Twitter. He posted on the Bainbridge Islander, which is a local publication that's distributed throughout the community.
And what he was posting about you, how did they vary between the different locations, or did they vary?
The same message, just the same lies and distortions that he came up with from thin air.
Meaning the claims of sexual assault?
Sexual assault, child trafficking, raping women, abusing people in my life, abusing my children, my stepchildren, anything he could throw at me.
And when was the Bainbridge Island bad list article posted?
It was in October 2018 is when it came to my attention.
Okay. And were you friends with them on Facebook?
None. I don't do Facebook. I'm not a social media person.
So, how were you able to see all these posts?
Through my friends and contacts of people. I opened a Facebook page just to have access to Facebook, but I've never posted or put pictures up or done anything on Facebook.
So you didn't have to be a friend in order to see these posts?
No.
Okay. And how long did that post on the bad list remain up for?
At least till 2021, my recollection.
Do you remember when it was taken down?
I think it still was up after the Hauser judgment ruling of 2021
When you say Hauser, you're referring to the Superior Court Judge
in
Hauser?
Kitsap County.
And what did you do after you saw the post made by Mr. Wade?
Tried to evaluate, I mean, for me personally, I was disgusted. I was in shock. I became antisocial. I worked, went home, stayed out of the public because it was so public. It was so where I didn't understand where it was coming from or why or what the personal attack was about. And I had to stand back and wait and watch to see what it was that I don't understand. And over the course of time, nothing came from it. No facts, no truth, as we discovered over time.
You say discovered over time. Are you referring to the discovery process?
Yes,
So you filed a case.
I did.
When did you do that?
Soon after the post went up, we did go through a local Pena Regina Municipal Court to attempt at an injunction to cease and desist. We got a temporary injunction. That injunction was taken away when there was a pro tem judge that gave the temporary, and then the sitting judge removed it. And then we went into Superior Court and trial.
Mr. Nelson, can you, if you can turn and grab the trial binder of exhibits?
There's two. Do you want yours?
Yes, ours, please. Thank you, Your Honor, for that clarification.
The black one, I believe, yes.
If you can turn to number 5. Excuse me, yes, number 5, that was correct. And Mr. Nelson, the document in front of you, which has been entered as Exhibit 5 for the plaintiff, do you recognize what that is?
I do.
And what is it?
That was my initial attorney representing me in this matter, Kent R. Bratt.
And this is the complaint?
Yes.
Okay. And Mr. Nelson, can you pull the binder for the defendant, please? And go to their exhibit number 3, please.
Okay.
And do you recognize that document?
I do.
And what is that?
That's the initial post that I recall seeing in 2018 October with my, it's pretty obscured, but there's a picture of me holding up a sign from a development I started in 2005. And this picture was taken about 2007. And then associated is this defamation from Wade about being a rapist, cheats investors.
And by the way, do you recognize the picture in the upper left corner?
I do.
Do you know who that is?
That's Frank Rowe. He had a carpet company on Bainbridge Island.
And who is Frank Rowe?
He was a convicted child rapist that spent time in prison. I'm not sure if it was 20 years, but it was an extensive period of time.
And he was another member of the quote-unquote bad list?
Correct.
Now, you mentioned,
I missed the name again. Can you tell me what that?
Frank Rowe.
Frank Rowe. Thank you.
R-O-E.
now you mentioned, Mr. Nelson, that through discovery, ultimately you learned that there was no supporting evidence from Mr. Wade regarding the claims. Can you explain to the court what happened in discovery?
Throughout the trial and throughout the hearings and motions and discovery, Mr. Wade never brought anything factual. He claimed to have 60 witnesses, never brought more than 40 names, but then claimed that he couldn't get a hold of any of them, didn't have their phone numbers, couldn't reach them. Nobody apparently reached him. This was a very public display of defamation on my character throughout the 2 or 3, 4 years that this has been going on, but nobody stepped up but Mr. Wade.
Did he, was there any, what was Mr. Wade saying, well, let me backtrack. How did Mr. Wade's presence on social media change during the course of the case?
Not a great deal. He just found different nefarious ways to hide his messaging.
So, did he continue to make comments about you?
He did.
How so?
He carried on with the charge of that I was also involved with child trafficking, which he claimed also involved the Bainbridge Island Police Department. He continued to post even after the ruling by Judge Hauser, negative commentary and charges of rape, and I'm not going to pay that effing rapist a dime. He continued to make it very public about me.
Did he make any comments about the trial itself, or the case itself, during the course of the proceeding?
Are we talking about the
For example, through the discovery process?
discovery process? He just continued to try and drive home his false allegations through misleading statements about amount of witnesses, which never showed up. His claim that there was rape, child abuse, abuse of others, screwing over my investors. I mean, he ran a campaign of trying to destroy my character. It was a very personal attack.
And were Mr. Wade's attacks on you purely personal in nature?
Indeed, felt very personal and very pointed and very direct. He had a number of people on his list, but no one more important than me, and I don't understand why.
What do you mean by that?
Well, he had other members of this bad list, but none of them took the brunt of his attention and distortions more than I did.
Did he also attack your business?
He attempted to attack my business and dissuade people from working with me. He went to banking institutions, claimed to talk to banking.
Objection, Your Honor. These are facts not in evidence, and it actually has nothing to do with the Bainbridge Island Bad List post.
So what's the gist of the question? We already have from the state court judgment that he was harmed in his business and they awarded $500,000 in damages. So beyond that, where are you going with the question?
I want to just make sure that, again, laying a foundation that the attack against Mr. Nelson wasn't simply attacking him in a personal capacity, but also attacking him in his commercial/business capacity. So there was a double-pronged attack to harm him both socially and financially.
All right, I'll allow the question.
Thank you.
Your Honor, the business doesn't have a judgment on here.
Your Honor, the business and Mr. Nelson are one and the same.
Well, it's his business. Maybe there was an entity or something, but yeah, the objection's overruled. Go ahead.
So, Mr. Nelson, if you can turn to Exhibit D of the defendants again. D3.
Okay. Right.
Can you read for the court the second paragraph, which is just one sentence?
Starting with years ago?
No, right before that.
Okay. Bill Nelson rapes women. He also cheats investors, is an alcoholic and a cokehead, and also abuses not only to his partners and wives, but his children as well.
In the next sentence, please.
Stay away from Bill Nelson, and definitely don't give him any money.
Now, was Mr. Wade deposed in the underlying Superior Court case?
He was.
Were you present for that
I was.
deposition?
Yes.
This was an in-person deposition prior to COVID.
Correct.
And do you recall what transpired prior to going on the record?
Indeed.
What happened?
Mr. Wade entered the room. You, the court reporter, and myself were seated, prepared to have the deposition. And Mr. Wade wanted to bring attention to the record that he had discussed witness tampering with the Kitsap County prosecuting attorney in their office, to the extent that witness tampering was going on and that the prosecuting attorney was prepared to file charges against me for witness tampering. Mr. Wade stepped in the breach and said, but I've held her off. If you're willing to drop the case and pay me $50,000, I will hold her off from filing charges.
And was this discussed under oath during his deposition?
Yes, it was.
And what did he say during the deposition?
Basically,
Your Honor, objection. I think you've already ruled that anything that is said in the deposition is only used for impeachment purposes.
I did. I'll sustain. Doesn't mean you can't use it later when Mr. Wade's testifying, but not now under record.
Certainly. Mr. Nelson, Judge Epp, was a motion How did Judge Hauser of the Superior Court react to the discovery issues of Mr. Wade?
Objection, hearsay.
Your Honor, we're talking about a court ruling. This is not hearsay. Also, I think the court can take judicial notice of this as well.
Objection, Your Honor. So, first of all, the order is not before this court because the plaintiffs made a decision apparently not to put it into the record. And second, any comments made from the bench are not part of any findings unless they're incorporated into the order, as of course this court will know. So, we maintain it is still hearsay, whatever the judge said from the bench, unless it was incorporated into the order.
And we have the order, or we don't have the order?
It has not been put into evidence by the plaintiffs. That was their decision. So they're making...
Response to the objection?
Well, again, Your Honor, so first of all, we do think under Rule 201, the court can take judicial notice, but we can provide a copy of...
I can't take judicial notice of a statement by another judge that's not in the record because I have no idea what was said.
Except counsel is mischaracterizing what I was saying in terms of the court's statement of the references to the court's ruling, the court's judgment, the judge's written ruling regarding the motion for default/contempt.
Why don't you ask him a question about what the court ruled as opposed to hearsay about what the judge might have said, if that's how you want to go about it. But I won't allow him to testify as to what the judge may have said, unless there's some transcript or it's in an order or something.
I'm sorry, Your Honor. I understand that, of course, I'm not trying to be difficult, but essentially what then we have is his interpretation of what the order said. And that's still essentially hearsay. If they wanted that order into the record and thought it mattered, they should have moved it, they should have listed it as part of their evidence and asked for it to be included in the evidence. They didn't. And now they want him to testify as what his personal impression is or memory is of what's in an order. And that's just inappropriate. It's hearsay. It's a weird version of hearsay. But
I mean, I think it depends a little how far he goes. I agree if he's trying to interpret the order, I think you're correct. That's not appropriate, but it's just a factual question. If he's asking them in your litigation, how did they rule on the discovery motion? And he says, well, they granted it or they denied it or they issued sanctions. He can certainly testify to that from personal knowledge. So,
and Your Honor, I would agree with that.
To that extent, I'll let him answer.
Okay, thank you.
So, Mr. Nelson, a motion for default was issued in this, was filed in the underlying case, which referenced the discovery issues, including...
Objection, leading statement.
Yeah.
Leading question, excuse me.
Sustained.
What was the court's ruling on the plaintiff's motion for default?
The judge's ruling was based upon Mr. Wade not providing any evidence into the record to support his claims as to...
I'm going to object, Your Honor. He just said it was based upon...
Yeah,
facts.
sustained.
Mr. Nelson, do you remember specifically what was said in the ruling?
Objection, it has to be the order, counsel, not the ruling. I'm sorry, and I spoke the order, so I apologize, Your Honor. I shouldn't have said that.
All right.
I apologize.
Sustained.
Mr. Wade...
Let me help. Let's just start with the simple questions. If you know, how did the court rule on your motion for default? Let's start there.
Ruled in our favor.
You can go ahead.
Thank you. How did the court rule regarding the regarding the conduct of Mr. Wade during the deposition.
I'm going to object unless he can provide the exact wording that was included in the order on that subject. Otherwise, it's merely his impression or recollection.
Mary?
If you can't remember, then obviously state.
It was a short answer from the judge, basically that his behavior in the deposition.
Objection, Your Honor, he's testifying.
Sustained.
Mr. Nelson, would it be beneficial, would you be able to recollect your record? Would reviewing a copy of the ruling refresh your recollection?
Objection. Attempt to get into evidence documents which they didn't identify ahead of time, had a chance to do so, and didn't.
Your Honor, we're not entering the exhibit. We're asking to refresh his recollection.
What's the rule?
Because, I would just point out, essentially, if he's refreshing his recollection, what he's doing is reading the order. So that's reading the order into the record. When, again, an exhibit they didn't bother to include in the exhibit list.
I'm going to sustain the objection. I don't think it's proper.
Thank you, Your Honor.
Mr. Nelson, can you turn to Exhibit 1 of the plaintiffs? Do you recognize what that is?
Frank Rowe?
No,
P1
P1.
P1.
in the black notebook.
Oh, I'm sorry. I thought you meant the white binder. Okay.
And what is that?
William Nelson, plaintiff, Easton Wade, defendant.
This is the finding of facts and conclusion of law from the Superior Court.
Judgment summary.
And did Judge Hauser make a determination of what was the purpose of Mr. Wade's comments, published comments about you?
He did.
And what was that?
His intent was to destroy me.
Objection, Your Honor.
Can you read paragraph 3?
Yeah, I mean, sustaining to the, unless he can point to something in the document where it says that.
On page 3 of the judgment, paragraph 3.
Third page of T1 is, I think, where he's going.
The third page.
Is that correct? Third page?
Third page of the judgment.
Presumably the third paragraph.
And the third page?
Third page.
The third paragraph.
The allegations were all false. Defendant's purpose in doing these things was to run Mr. Nelson off the island.
Thank you. Does this order address Mr. Wade's future conduct?
His future conduct was limited in speech, defined by the words he had been using to defame me.
Are you referring to an injunction?
An injunction against the words that he used to defame me.
So he's prohibited.
Objection, Your Honor. Where is the plaintiff reading from in this order?
It's in the order.
What page are we on and what paragraph?
Mr. Nelson, can you turn to...
Hold on one second. I think the injunction is page 6, starting at line 10.
Thank you.
That is correct, Your Honor. Section 5 of that.
Paragraph 5, yeah. All right, go ahead if you have restate your question, maybe,
Thank
if you
you.
would, please.
So, Mr. Nelson, have you turned to page 6?
I have.
Okay. And can you go to line 10, which is section 5? Are you there?
I am.
Okay. And what is Mr. Houston currently enjoined from stating or inferring about you?
Mr. Nelson raped a woman in Fort Ward community. Mr. Nelson engaged in a cover-up with the Bainbridge Fire Department of said rape. A victim of Mr. Nelson, Elizabeth Cultrider, committed suicide as a result of his actions. Mr. Nelson engaged in illegal conduct at a speakeasy called the Chicken Coop, including paying money and liquor and drugs in exchange for illegal and immoral conduct, including rape and child abuse. That the illegal conduct at the Chicken Coop was done in conjunction with the Bainbridge Island Police and Fire Department. Mr. Nelson conspired with the Bainbridge Island Police Department to cover up the alleged crimes. Defendant accuses Nelson of such as running a child sex ring. Mr. Nelson committed domestic violence against his former spouse. Mr. Nelson has beaten the shit, excuse my language, out of his stepchildren and abuses children. Mr. Nelson is a cokehead. Mr. Nelson stalked Mr. Wade and tried to kill him several times.
In this judgment, did the court make a determination of, how did the court characterize these statements in the court's ruling? Let me rephrase the question, Your Honor. Please turn to page 2. You can turn to section 2, line 9.
In October of 2018,
Yes.
Mr. Wade began publishing defamatory statements about Mr. Nelson. These statements included allegations that he raped a woman in Fort Worth on Bainbridge Island, and he engaged in a cover-up with the Bainbridge Police Department. Allegations that a victim of his, Elizabeth Coltrider, committed suicide as a result of his actions 4 years after the election.
Objection, Your Honor. This document speaks for itself, and this doesn't go to the issue in this case, which is his intent. Mr. Wade's intent.
Yeah,
This is duplicative, too.
yeah, I don't think we need to have him, let me just comfort you that Exhibit P1 is admitted. I've read it a bunch of times, and I've already ruled that it's preclusive. So if that gives you any comfort, I don't think it's really necessary for Mr. Nelson to sort of reread the document to me in the record.
Thank you, Your Honor. And Mr. Nelson, since the injunction has been put in place, has Mr. Nelson's conduct towards you changed?
Mr. Wade.
Excuse me, Mr. Wade's conduct. My apologies.
Mr. Wade continues, even after the judgment, to post false statements about me.
Are any of those similar to what he's prohibited from posting?
Rapist.
Objection, Your Honor. We haven't received any evidence of this.
Your Honor, they're in the court record. If we wanted to look into the posts
Under their own court record, and you can cross-examine on these issues if you don't think your client's posted anything, or ask him if he has any documents that proves it, but I don't think there's any problem with the question as any post-injunction comments that may have violated the order seems like they would be relevant to Mr. Wade's intent. So I'll allow the question.
Thank you, Your Honor.
Objection's overruled.
Thank you, Your Honor. So, again, Mr. Nelson, has Mr. Wade continued to make posts similar to those that are described in, that he's precluded from posting?
Yes.
Such as what?
To the extent that he has made a statement that I'm not going to pay that lying sack of rapist anything on the judgment.
This was posted online?
Yes.
No further questions at this time, Your Honor.
All right, just give me one moment, please. All right, Ms. Lynn, I'm ready when you are.
I'm gonna.
Oh, I'm sorry, Ms. Lynn, I apologize.
You didn't know until I said something. All right. I'm just going to stand up because I'm short, so it's easier to see me.
That's fine, just make sure you're getting into the microphone.
Can everybody hear me?
It's coming through, Rebecca.
It's coming
Fine.
through, yeah.
Okay, yeah, you're fine, thank you.
Okay. All right. So I'm just going to be going through some of the testimony that you gave. I'm going to start with you first said that Mr. Wade came up with these claims of sexual assault out of thin air. Is that correct?
That's correct.
Okay. And you said you looked at the Facebook post after you were alerted to it, the one in the bad list?
Correct.
Okay. Did you look at comments that other people made on that thread?
There was very few comments really clarifying any support for Mr. Wade,
That's not what I asked
but
you.
I did,
I asked you if you read them.
of course, yes.
Okay. And but then based on what you just said, so you're asserting that there was only a few comments about people who supported him. Is that what I heard you say?
To my recollection, there was people that would cheer him on, but as far as any factual support, no, I didn't see anything.
So you didn't see, did you see anybody else making comments on that post or on the page, excuse me, I want to be precise, making other assertions against you for engaging in problematic activities?
No.
Okay. Sorry, just one moment, my co-counsel is, okay. All right, so I want you to turn to Exhibit D2.
That's the white notebook. Yeah.
You got to remind the court that the court has not yet admitted this into evidence, so I'm aware of that.
D2.
Yep.
Okay.
Okay. So that first page, does that look familiar to you?
On a Wade post, yes.
Right. And is that the post that you saw, one of the posts that you saw when you looked at the Facebook page?
I'm familiar with this post, yes.
Okay. And we looked at another one a few minutes ago, which was I think the first post on the bad list, which was in your exhibits. Do you recall that?
Yeah, the picture of myself.
Right, yes.
Yeah.
Okay. And then, so is it your recollection that this comment that we're looking at now from Mr. Wade is one that was below that first one we looked at? And
Was this one in the same sequence?
I'm
Is that what
sorry.
you're asking?
I'm sorry. I misunderstood. Sorry. When you went to the bad list Facebook page, did you see this comment? The one that we're looking at now?
I don't recall when I saw this,
Okay.
but it was early on, yes.
Let me just make sure I'm looking at the right
Yeah.
thing. Right. Are you on the first page of D2, the
Yes.
October 4 at 11:46 post? Okay.
Yes.
Yes,
Okay.
So you are familiar with it, correct?
I am familiar
Okay.
with it, yes.
Okay. And I was just a little confused because, again, I've had to jump into this in the last few days. So this post was, I'll represent to you, that this post was made on Mr. Wade's personal Facebook page.
Mm-hmm.
Is that a yes?
Yes,
Okay,
that's
sorry.
correct. Yeah,
Just for court purposes, we have to say yes or
Yes.
no. We can't do uh-huh or
we're correct,
That's
yes.
why I was asking
Thank
for
you.
clarification. Okay. But did you go to Mr. Wade's Facebook page and see this post after you were made aware of the bad list?
Yes, with fascination.
Okay. And then, so I want you to look through the next few pages, and see did you look at some of the other posts that were made in response to his post on his personal Facebook page?
Mm-hmm.
Is that a yes or no?
Yes.
Okay. And do you see the post made by Elena Brooke Simcoe Seisel? I don't no idea if I'm pronouncing that right.
Excuse me, Your Honor, I'm going to object to the extent that any of these comments are attempting to challenge the findings of fact in the final judgment, plaintiff's exhibit number 1.
Well, You are correct in what you just said, but I don't think that prohibits her from asking these types of questions. We are definitely not relitigating
Yes.
findings in the order, but she can ask these questions. She can ask these questions. I need to ask you one question about this exhibit, Ms. Yosman, just to make sure I understand it. I'm trying to get the chronology. Is the first page the earliest and all the following pages come
Yes.
later?
It is,
All right.
yes, sorry.
So I'm sorry, now I've
No.
distracted everyone, so would you please ask your question again?
So just to be clear, we're talking about comments made in response to Mr. Wade's post on October 4th, which is the first page of this exhibit. So I hope that makes the record clear.
It does,
Right.
thank you.
And so then I was asking about the comment by, I'm just going to say Elena Brooke. It's on page 3 of this exhibit. Did you see that one? Yeah. It's at the top of the 3rd page of exhibit D2.
It's highlighted.
Oh, right at the first page. Well, yes.
Okay.
Elena Brooke, Simcoe. He was horrendous. I remember him sniffing any young woman he could get close to.
I think she's just asking you if you saw it.
Yeah, that's all.
I thought maybe I should read it.
No, that's
Sorry.
fine. That's fine. But you still need to answer the question, because you could just be
Have I
reading
seen
for
it?
the first
Yes.
time.
I have seen this.
Okay.
But this has been some years ago. So
Sure,
keep
I
in mind.
understand. And do you know this person?
Have no idea who she is.
Okay. And then down at the bottom of this page, there's another comment from Shannon Evans. You don't need to read it. I'm just asking if you had seen it when you went to Mr. Wade's
I have, yes.
Facebook page.
Yes.
Okay. The next page, there is, I'm going to repeat from Ms. Evans, but there's a post from a Tracy Lang.
Yes,
And did you see that comment also when you
I
looked at it?
did.
Okay. By the way, we have to just make sure not to talk over each other. So even if you think you know what I'm going to ask, please let me finish my question so that before you answer, okay?
Yes.
Thank you. Because somebody at some point, a court reporter is going to have to maybe take this down. We don't want to make their life miserable, okay?
Thank you.
All right. Then I'm going to turn another page. It is, I think, it's 5. Okay. The numbers are so little that I'm struggling to see the numbers down at the bottom of the page. And then there's another comment from Shannon Evans. You saw that one as well, I'm sure?
Yes.
Okay. I'm going to turn the page. Let's see. It says 6. So then some other comments from Miss Evans. There's another comment from Ashley Cross DeGrow. You saw those?
Yes.
Okay. And then next page, there's a comment from a Samantha Goakey, Goakey. Did you see that one?
Yes.
Okay. Okay, next page is 8. There's continued comments from a Zakara Stratman. Did you see those?
Yes.
And you saw the comment from Doug Hunt.
Yes.
Okay. No, it's not. Then we're going to go through some pages. So let's turn to page 13 in the exhibit D2. There, if you look on the bottom of these pages, there's like a square that's not fully complete on the corners down below, and there's tiny little numbers underneath it down at the bottom of these pages.
You're on
It's the
D2?
second to last page, if
Yeah.
it helps.
I was trying to just help you
On
find it.
D2.
On D2, yeah, next to last page.
Yeah. And so, again, did you see more of the comments by Shannon Evans?
Yes.
Okay. And then the last page. Again, further comments by Shannon Evans and Ryan. There was also Mr. James. Did you see those comments as well?
I'm on the last page, but all I see is Houston Wade and Tracy Lang kind of cut off.
Huh. Okay. Well, maybe go to the next to last page, maybe, because you have a page, you described the page.
Shannon Evans, Keith Brodsky, Ron James.
Yeah, that's the last page.
Okay.
Okay, all right. Now, those some of the comments that you were referring to earlier when I asked you about looking at other comments?
I've seen these years ago, yes.
Okay. All right. And I think I asked you about a couple people specifically, but did you know any of the people who commented on here?
Shannon Evans, Tracy Lang, Ashley Cross DeGrosse,
Okay. Okay. All right. Is that it? I don't want to cut you off.
that's, yes.
Those
all
are the
that
people you know.
I would
correct?
know
Okay.
of
Okay.
in the community, yes.
All right. And did you ever take any action against any of the people who continued to make negative comments about you on this Facebook page?
No,
Did you communicate with them in any way? Tell them to stop saying these things about you?
I had no communication in relationship to this. Shannon Evans, I knew from a distance in the community I was developing at the time, but we never had any interaction. Hi, how are you at the coffee stand was the extent. Ashley Cross DeGrosse, she used to frequent this speakeasy backyard they called the Chicken Coop, which was a gathering place for neighbors and community members for socializing, had music, had a little non-charge backyard bar, outdoor fire pit. Many people gathered there. And Ashley was one, yes.
Okay. And then I think you said you knew Tracy Lang.
Tracy Lang is a co-tenant in the building, commercial building I'm in. She has a tattoo shop. I have a construction company office.
Okay. And wasn't there one other person you said you knew? Maybe I didn't write him down, so I.
Shannon Evans,
Tracy
Ashley
Lang.
Cross, and Tracy Lang.
That was it.
Yeah,
Okay, thank you. Sorry, I didn't get a chance to write those down. Thank you, Your Honor.
yeah.
Okay. And so you didn't file any lawsuits against them for saying these things about you on this Facebook page, correct?
No, I did not.
Why didn't you take action against any of them?
Every wolf needs a pack, and that's who these are. This is part of a pack of people that follow his Facebook page for legitimate reasons or illegitimate reasons. It's a social network for people like Mr. Wade. I'm not associated with.
I understand that, but they nevertheless made some pretty harsh accusations
I
against
don't
you.
consider these to be harsh at all.
Somebody accusing you of,
Hearsay, I would say. hearsay within the community, somebody to support somebody that's trying to make himself a social media giant.
Preliminary matters before we start?
These are followers of Mr. Wade.
All right, Mr. Wade, you can return to the stand if you would.
I understand that, but you still haven't answered my question is why you didn't take action against them, because they made accusations. Let me finish, okay, because I can see you getting ready to answer. They made accusations against you,
Just remind you, you're still under oath.
saying things like, he prefers them young, blonde, and uneducated, and other stronger comments. Don't let your daughter near him, I'm serious, he's super creepy, and tried hitting on my son's girlfriend when they were in high school.
I would like to
Ashley
go back to
DeGrosse
plaintiff's exhibit
DeGrow.
2.
Everyone knows to keep their daughters
Exhibit
away.
F.
All those kinds of things are analogous to what Mr. Wade was saying, correct?
Aren't they protected under the First Amendment free speech?
Sorry, you don't get
Yes.
to ask me questions,
Yeah,
you
you
got
gotta
to
answer
answer
the
mine. Thank you.
Okay.
Rephrase your
When
question.
did
or
you find
repeat.
out about the state court's
Go ahead and ask
judgment?
me the question.
That
again.
was in February
Okay,
2022.
so I asked you why
And
you didn't sue
Exhibit
them,
F,
given that
if
they
you
also
can
said
look,
things
what
against
is the date on
you.
that?
that were
January 30th,
analogous
2022.
to what
So
Mr.
you
Wade
found out
said.
about the state court judgment
My main
after
concern
you
with
had
Mr.
written
Wade.
this post.
Yes.
Again, you
When
haven't
you
answered
found
my
out
question.
about the
I had no
judgment,
reason to sue those
did you
people.
take
It's
down the
hearsay.
posts about Mr. Nelson?
I did.
So why wasn't Mr. Wade's comments hearsay?
At least everyone I
Because
could
he
find.
went personally against me,
And when did you
Much
take
more
down the
aggressively
October
and
4th
charging
and
me
the
with
October
rape, child
21st
abuse,
post about Mr.
child
Nelson?
sex
when I
rings,
got
child
served,
trafficking. I mean,
for the temporary
egregious.
restraining
Wouldn't you agree?
And when did
I'm
you
not here to
get
answer
served
questions.
the restraining?
Okay.
That was October 24th, 2018.
So, but it's not egregious when
And
somebody
was
says
Mr.
you're
Nelson
super
there?
creepy and tried hitting on a high
Not the
school
original
girl,
service, no.
or that everyone
When
knows
was
to
he?
keep their daughters away.
The next day, he
Wasn't going to
attempted to serve
open
me
5
again so he
lawsuits,
could
ma'am.
videotape me being served at work.
Okay.
And then he gave that videotape to Richard Lee Rynearson to
Take
post on
down the
YouTube.
king rat
And then what
take
happened
down
with
the
that
rest.
video?
Richard Lee Rynearson posts it constantly
Now,
on
but I'm
Reddit,
going to go back to kind of
Twitter,
where I started with
Facebook,
this, which is
and
you
other social media
asserted
platforms.
that Mr. Wade came up with
And
his
so
allegations against
Mr.
you,
Rynearson was
out of
not
thin air.
there.
He was not.
right?
It
Correct.
was only, it was Mr.
So-
Nelson who took that video.
Yes.
Don't you
and,
think the fact that
along-
other
He was with the
people
man who
have
served me.
similar
And is that video
beliefs
still
about
up?
you that
It
they
is.
posted on his website indicate that Mr. Wade did not make them up out of thin air?
Objection,
has
Your Honor.
Mr.
Mr. Can I interrupt you for 1 second?
Yes.
These allegations have already
The
been determined
October
as a matter of law
24th,
themselves.
2018.
And now we're getting into
What happened on that day?
That's when I was
That was-
relitigating
With what?
the temporary restraining order.
The underlying
uh,
judgment
Cambridge
and
Police
findings
Service.
of fact.
I'll overrule it. I don't think we're not relitigating the other judgment. She's trying to indicate that if a bunch of people
And the
thought this
judgment is
thing,
from
maybe
what?
Mr. Wade believed they were
So,
true, and that might go to his intent.
Yeah,
I'm not throwing the Why time he in posted
so-
it, so I need to get clear on what we're talking about.
Sure,
I
so,
think, objections
Would you like
overruled.
me to ask some
You can
questions?
ask these questions.
Thank you, Your
Why don't you
Honor. That is
explain it to
exactly
me
why.
first
Okay.
without adding anything new?
Okay,
sure.
And
So-
if not, then we'll ask you.
original post
All right.
that the state court litigation
Now,
was about was
you,
his personal post of October 4th.
Testified.
Of 18,
that-
so everyone-
2018, and then
Clear.
on October
I mean,
4th,
And we've
sorry,
talked about
October
this
21st
before.
one of
The
2000.
statements
that was the one
are
with the English
false
Iron
for the
Plaza.
purpose of this
Yeah, and
trial,
then he was
because
served
that's
with a
what the
temporary
state court
restraining order
found.
by
But
Mr. Nelson.
By the
when he
Cambridge
made the
Police.
statement,
By the
whether
Bainbridge
he knew they were
Police,
false or believed them
on
to be
October
false
24th.
can be relevant to his intent, and that's why I'm allowing the line of questions. To what,
And
take
I'll be
down the
clear
same
again, I'm
stuff
not
that
trying to.
became the basis for the judgment?
Ruling.
Correct.
All right.
I understand completely, Your Honor.
It was just here. It was
You
a
said
temporary restraining
the
order.
bad list
To take that down.
was
It didn't have
taken down
specifics at that point.
in 2021. Complete. Is that
All right,
correct?
well, go ahead.
Yeah.
Just maybe ask some,
Correct.
maybe go back through that
Okay.
question.
And
I
then
think it's
how do you
important
know
because
that?
I'm not sure I
Didn't
have
see the
everything
post after the ruling.
clear on that.
Okay. But did you look before the ruling came down to see when it had been taken down?
Yes.
So, okay, so you
We're
looked
at
at it
October
in
24th.
2020?
Then what he
Correct.
was just
And you
testifying
looked at it in
about
2019?
took place on October
Yes.
25th,
Okay.
which is when Mr. Nelson was,
Served me the papers again.
And what was happening on it?
well, a process
In 2019.
server.
Yeah, Francis served it. And Mr.
Served in the
Primarily
TRO.
Mr. Wade's
Right.
That's
post.
what's being served.
Yes, yes.
His activity of these commentary
Sorry, I was trying to say
commentary
it without
activity came
embellishing.
after his initial post,
And
and if you look at the
did
dates
you go
and
to court
times
for the temporary
of the
restraining order?
follow-up posts of others, they fell off
Twice.
fairly quickly.
First time.
As Mr. Wade
Nelson
continued
had
to
gotten
march on.
second Brett as his attorney. Brett
Posting
said he
about
needed more
it.
time, asked for continuance. Back
So I
second
want to be
time.
clear, you're
And this
contending
time they asked
that
for the temporary
after
restraining
you
order
sued Mr. Wade,
to be dismissed.
and there was a
serve no
hearing on the
lawsuit.
temporary
Which is
restraining
up to
order,
you.
et cetera, and the case is progressing.
And
And Mr.
in
Wade
that temporary
continued to post
restraining
things
order,
on his
you
personal
had filed
Facebook page
a declaration.
and on the bad list,
Uh,
continuing to make these accusations against you.
Yes.
Okay.
I
And
can't remember.
Do you have evidence
if I
of that?
I think the declaration was filed against the
We have
loss.
a whole book of evidence.
And you
I
turned
in
can't
this
to
case,
page
or not in the state court case?
7.
In the state court and also in this case as well.
I just want to check something here.
And excuse me, the
yeah,
time
this
frame of
is,
your question was
this is the-
while
the-
the
there was an
law-
injunction
state court
restraining
lawsuit
order
was
hearing
pending,
in the
but
county
prior
court
to judgment.
that replaced.
Yes,
the-
correct. I said 20, I asked him about
Okay, so just
2020,
to clarify,
2019.
the
I was
TRO
just
that was
looking
served
to make
on
sure I have
October
the state court
24th was
judgment correct. It
dropped.
was
was
entered
dropped,
on
yes. And replaced with the
September
county-
27th,
the state
2021.
suit in the county court.
Okay. And D7, you see the title.
I will
that-
also just make
Can you
note.
read
on
the
this
title of
subject
this document?
that
Declaration
in the
against motion
findings
for
of
temporary
fact,
restraining order, temporary
there
injunction.
was
And you wrote this.
I did,
no,
yes.
no findings about continued posts. It's only posts in October 2018 that are the subject of the factual findings in the
Can
order.
you turn to page 7?
All right.
And we're looking at
now, I want
paragraph
to
21,
confirm
line
Mr.
that-
19.
Let me just, just since you made that statement, let me just
Like me to
say,
read it?
unless you want to point me
Yeah,
to
can you
something
read
in that
that?
judgment, I
I
find
created
it
the Amber John bad list
not
as
as
a news
clear
page
as
to
you
inform the
stated,
community of who the
because
predators are.
paragraph 2
And Mr. Nelson
findings
fits
say
that
in
bill to
October
it. I didn't stalk Mr. Nelson, I didn't harass him. I wrote an
18,
article
Mr.
about his
Wade
predatory actions.
You stand public. Okay,
Confirmed
I
by
see,
many
I see your,
hearings.
I see your
It
honor.
doesn't
Goals to warn
preclude
people,
that-
especially young
I don't
girls,
have
to
any
stay away from
evidence
Mr.
right
Nelson
now
for their own
yet.
safety.
Right.
Purpose of journalism is to expose abuse, and that is exactly what I've done. The abuse of women and girls and the
Okay,
abuse of the
that's fair.
system designed to
Thank you.
serve and protect them.
Not that I need to approve you.
Well, I just think it's important
No,
for
I-
everyone to
I-
understand. I don't want to surprise anybody
No.
with anything unnecessarily.
Precision.
Just at the bottom of these pages, you'll see
Works.
like
It's
D7, the
necessary for
left-hand
Yes.
corner, in the middle of the
Okay.
page, you see
Um,
a page
now,
number.
Can
you turn
when we
to
looked at
page
previously
10 of
the
D7?
order entered by the court, your counsel was pointing
Yes.
out that the court found that
I mean, this was
Mr. Wade's
an
purpose
exhibit admitted
was
into
to
court.
run Mr. Nelson off the island. Do you
Correct?
recall seeing that?
Yes.
Okay,
Yes.
and this is
Okay.
an
Do you
email
still live on Bainbridge?
I
from
do.
Ashley Cross DeGrow. You see
And
on
you
the
still
left-hand
operate your
corner?
business?
Yes.
I do.
And I understand,
Could you
correct me if
please
I'm wrong,
read
that
what
you,
you know?
your business did have
Yes,
to file
Houston, there are a few
bankruptcy.
stories.
and-
Objection, Your Honor.
2013.
This was a
Thank you, okay.
um,
And you
defendant's
came out of
state
that
of
bankruptcy
mind
and are
of why
continuing
he
to operate
actually
that business?
created the Bainbridge Island
was a
Bar List.
struggle.
We're
Yes,
not
I
debating
am.
whether or not what he
Sure.
wrote about
And
is
but I'm sure
true
that was
or
probably
false. We're going
big
directly
result
to what
of
the state of mind of
2008
Mr.
financial
Wade
crisis,
Parkinson
right?
is about.
Correct. He wants to testify
Um,
as to his state of mind,
And
that's fine. but-
now, you also testified that Mr. Wade has continued
Just hold on one second if you
to
want.
make posts against you, violating the language of the court order. So since September 27, 2021. Is that accurate?
That's correct.
Okay. And when did you see these posts?
This is now September
2023?
2023, thank you.
Yeah, all over the rule.
In the
overrule
spring of
objection. I think
2023.
It's fine. We're talking about his subjective intent here, and it
And
doesn't
where did
really
you see
matter
these
what
posts?
the content of this is true or not
Facebook.
necessarily.
And whose Facebook page?
It's what the information that he
Mr.
had at
Wade's.
the time, whether it was true or
Personal
not,
Facebook page?
could be
Correct.
relevant to his intent. So,
Okay.
not allowing it for the truth of the matter, but I will
And is that
allow it.
the one you
Mr.
said, you
Wade,
quoted him as saying,
Houston, here
you're
are a few
not going
stories
to
I can
pay
think
that
of. I
lying
hope they
sack
help.
of blank that
Bill
rate
Nelson
is.
is a creep. I met him when I was probably around
Any money,
13 on a
correct.
job site with my
Right,
dad.
okay.
I was one of the few girls my age that already developed a sizable chest. I was
Okay,
regularly
and
mistaken
he
for
put
16
that
at the
on his
time.
personal
The old
Facebook
creepy
page,
men
correct?
seemed to find
Yes.
acceptable age to
Okay.
hit on me. And I
And,
go clearly looking down my shirt, my dad's saying
Have
something
you
to him like, hey,
taken
that's my child.
action to, in
My
the
poor
state
dad
court
had no idea what to
to,
do with me other than to warn me. Afterwards in the truck
get
on the way
relief
home,
because
my
of the
dad said to me
violation of
very
the
seriously, stay away from
restraining
me.
order?
I've heard my
Been
dad
focused on this matter,
say this
but
quite a
no,
few
I have
times.
not.
I'm sure my dad has
Okay.
seen many things happen with
And do you
Bill.
have a copy
We
of
went to high
it?
school together, and I've never heard a good story about him
Post?
from my dad. I've
Les,
had quite a few experiences
Alex,
with
do you
Bill,
have-
and I really can't recall any of
Hang
them
on.
being good.
I don't have anything in front of
Multiple
me.
occasions
Okay.
I've encountered Bill at the
You
coop,
can't
and he
ask
shamelessly hit on me and
questions
touched me
or
without
your,
consent.
your counsel.
I pretty clearly remember one specific time he touched me without asking.
Did you make a
There
copy of it
was a
when you saw
resurgence
it?
of partying at the chicken coop at some
It would
point.
be in the
This time he
record.
clearly grabbed my
This has
butt,
been a
and his son
long
almost got in a
running,
physical fight with him about it.
uh,
He tried to play it
event,
off that
so
we were in a small space, his hand
I'd have to go look in
grabbed
the
my
record,
butt.
man.
But at his height,
Well,
he would have to bend over a fair
What I'm
amount to
asking
get
you
close.
is, do you,
On another
did you
occasion,
make
he
a copy,
brought a date
print
to my friend's
a
house.
copy
We
of
headed
it?
over to Bremerton
Post.
on the boat for dinner.
When you
All
saw
night, he
it?
was
We
cracking
keep
portions of
electronic
drinks on
file
our
on
boat,
everything,
made me
Mr. Wade
and obviously
says and
her
does.
very uncomfortable.
Okay,
She obviously
who's
was
we?
not having a good time, and he was pushing and pushing her. She miraculously
It's,
made it back to my
on
friend's
a,
without puking off the
in
boat,
my office,
but did
it's
so as soon as we got
within
back. My friend
my
insisted
record
they
keeping
stay
that
the
I
night.
keep
She just wanted to get away.
track of
I don't know what ended up happening to her
old,
that
what's
night, but based
new
on how he was touching her and giving her even more
with
alcohol.
Mr. Wade.
More alcohol, anyone could have
Okay,
guessed what
so
happened.
now
after
is that you personally or staff?
staff.
Thank you. And actually,
And who in your office is
she
responsible
also
for
made
keeping track
a
of what
post
Mr. Wade
or
does?
comment, I'm sorry, to your.
I use
October 4th.
primarily
She did.
Timmery Jenkins, who has been very helpful in managing the whole Facebook matter with Mr. Wade's
And can you
posting.
turn to page
Can you spell that first
B7
name?
of, sorry,
Timmery,
B711?
T-E-M-R,
Yes.
T-E-M-R-E, Timmery
Okay,
Jenkins.
yeah, thank you. It's an unusual
And what
name.
is
Yeah.
We have it right.
This
Anybody
is-
else?
Same objection, this is hearsay.
Deb
We have
Prouty?
No way to authenticate what this is.
This is my office
where it came
manager.
from.
Can you spell the last name, please?
P-R-O-U-T-Y.
Okay.
Documents from.
Anybody else?
We have.
No.
Okay. So.
I'm
you-
sorry, I missed the second name. Would you give me the
This
second
is
name?
also
Deborah
going to the state of mind of
P-R-O-U-T-Y.
Mr. Wade. This was already admitted in
Well,
this.
It is, but he's
All right.
going to have to be
And
able to at least
So those are the two persons in your
authenticate it,
employ
tell us what it is
who
first,
are
because it's not
specifically
clear from
tasked
just looking
with
at it.
keeping
So if
track
he's
of
able to do
Mr.
that,
Wade's
then
social media.
I would agree
that
with what I
correct?
said on the prior objection, that
They run the,
they need
they
to start some
manage
foundation on
the
this one.
business, so it's not the only thing they do.
This is a
Yeah, I'm
rescue.
sure. Yeah, well, one would hope there was not a full-time
Do
job.
you recognize?
Yes.
Well, it was
I do.
one time.
And what is this?
But
This is a
they are the
direct
ones who are
message
tasked
on
with
Facebook from Jared
keeping
Willow.
track of what Mr. Wade.
Yes.
Yeah.
yeah.
Same objection,
To
Your Honor.
myself.
You need to let me finish.
There's
What Mr. Wade
nothing on
says.
this exhibit to identify
Yes.
where it came from.
And what are they supposed
Wrote
to
it.
do when they see him posting
Anything.
about you?
Keep record of it.
Okay. So if Mr. Wade did post what you testified to a little while ago, somebody in your office should have kept a record of it, correct?
Correct.
Okay. And then what did they do with it?
No, I'll overrule it. I think you can put it in.
Keep
He's
it in an
testifying to
electronic
it.
file.
Okay. And do you turn it over to your attorney?
If you can just rephrase, who was
So,
this from again?
it's from
I've
Jared
turned
Willow,
everything over
a
to
friend of
my
mine's direct
attorneys.
message on Facebook.
Okay.
Can you spell
So
that?
if there was a
Oh,
copy
goodness.
of
Or at least phonetically.
post that you said occurred in spring of 2023 on Mr. Wade's Facebook page, then there would be electronic evidence of that.
Close enough.
I could be really wrong on that. It's
Evidence
French,
of
I don't know.
that you would have turned over to
And
your
can you
attorney.
please
Is that
read?
correct?
He sent me a message
Okay.
that
To my
says, glad
knowledge,
the truth
yes.
is gone, F those guys. I was dating a girl, showed
do
up
you
there, she
check
was
in?
wasted, Nelson had his hand down her pants.
These ladies?
And I replied, I was told them to
About
stay away from there,
whether or
some of
not
them
Mr. Wade's
did, some of them had to
posting
find out.
anything, get an
Well,
update?
supposed to say find out
We
the
don't
hard way.
go
but I
online
don't
every
know.
day, no.
I feel sorry for
But-
those ladies.
When is this document?
On occasion, we'll do
This would have been
a
from
sweep
October
of
16th.
anything, Twitter, Facebook,
2018.
any other outlets that we've known Mr. Wade to use in the past and see what's up.
Okay.
Can you
But
flip
what
to
I
the
was
next
asking
page?
is if they find something, they would tell you.
Yes.
Yes.
And do you recognize
And
this
then
document?
is
Yes.
it you or them
What
who
is
would give it to your lawyer?
This is a declaration that
I
Ryan
would
Lambert
authorize
filled
it.
out for
They
the
would do
municipal
it.
court
Yeah.
hearing.
Okay.
There's almost a municipal court hearing on
And that's
Bainbridge,
been
the TRO.
consistent
Nelson.
since
I'll give you-
basically
And
kind of
who's
this
Ryan
whole
Lambert?
can of worms.
He
opened up
is
in
a blacksmith
October
that lives on
2018.
Bainbridge
Correct.
and a former member of the Bainbridge Fire Department.
Is there anybody else who
Read
would
the
have
letter?
access?
Your Honor, same objection. This is hearsay.
Overruled.
Not to my knowledge.
Okay.
Sometime around 2006, while I was a member of the Bainbridge Island
All
Fire
right, let me just
Department,
double check my
I was
notes.
invited to attend a party at the Chicken Coop Speakeasy. When I went, it was hosted by Bill Blakely and Bill Nelson. There were other members of the fire department and Bainbridge Police Department off duty that were attending.
Oh,
Shortly
okay.
after arriving, it was revealed to me that they
Sorry,
would be having a stripper.
1 second, sorry.
That was still a Bainbridge High School student. I was
and
not
who
okay
is
with any
Richard
aspect of
Lee
what was happening.
Rainierson?
I had a child that was a student at PHS.
He
I thought the
is
whole situation was
a
very
member
wrong
of the community.
and would not participate
I've never
in
met
any way,
in
so I immediately
person.
left.
Apparently, he's on Mr. Wade's watch list.
Okay, and have you
Excuse
communicated?
me, can you like spell or give me that last name again?
Can you go to
It's
the
a big
next
one.
page?
I will spell it.
Okay, that's good.
Yes.
That's why I had to ask.
Do you recognize this?
Okay, I got it.
Yes.
What is it?
It's an email Katie
R-Y.
Fisher sent to me, and then maybe she also wrote a doctor's declaration for me for the court case, the Superior Court case.
All right, thank you.
And can you please read this email?
My name is Katie Fisher. I
and
met
so,
Bill Nelson at a bar in
you've
2012.
never met him in person,
September, I
but you
believe.
have
I've been
communicated.
drinking with friends at Isla Bonita.
I've
bar on
had several
Bainbridge Island.
communications
I
with him.
remember talking to him much as he
via
was older than my dad. He was
email.
20 years older than me.
Okay, email.
After the bar, I remember
And-
very little. Being in
I'm
the
sorry.
car
And
and him
you
telling
said
me
that
he was
he was on
taking me
the
to his home.
bad list.
I remember being in his big
No,
master
he's on the bad
jacuzzi
list,
and then
but I
brief
know
memories
he's
of him on top of me.
Not a friend
I
of
came to enough to
Mr.
get a ride
Wade's,
home
nor is
immediately.
Mr. Wade a friend of his.
I ride home immediately and shrugged the incident
Okay.
off as I was
And then
embarrassed.
have
Now that I've heard it's happening to
Mr.
other women
Rainierson been
before, I'm
someone
questioning
who's
a lot
given
more,
you information
how and why I
about
would agree to
various
go home
posts by
with
Mr.
a
Wade,
man my dad's age,
screenshots, records,
etc.
of his
Anyhow,
posts,
I
et
hope
cetera.
this help. This stop.
Not to my knowledge,
So what is the date of this email?
just
December
commentary.
9th, 2018.
Okay, and
I'm sorry, what do you mean by
everything you just
commentary?
read, all the dates are
Just
after
good
you
luck.
had written.
Keep up the good
article
fight.
in Bainbridge Island.
Okay,
Not the Jerry Roulette one. That was before.
but
I
he
posted.
hasn't sent you any information.
I made the
about
Cambridge
Mr.
Island
Wade.
bad list.
not to my knowledge, no.
The others were after, yes. Or,
Well, that kind of puzzles me
One
because
sec.
how would you not know
yes,
if
yes,
you
because
sent you
actually it was
something?
after.
My
when,
primary source of information is
Cambridge Island
internal.
Municipal Court.
Okay, well, I know,
And
but
all of
I'm
this information was
curious
told
as
to
to
you
how
prior to
Mr.
you.
Rainierson
Yes.
sent you
So
something.
this
How would you not know?
information that you just read was presented
It's
to you
been 5 years
to
in this
help you
process. I don't
with
recall
the
Mr. Rainierson
December
sending me
restraining
anything
Yes.
other than support.
Okay, and he didn't send you any videos that he had taken of Mr. Wade?
No,
Will you ask that one again?
No other
Ms. Hunt?
photographs that he took
sorry,
of
pardon?
Mr. Wade?
I missed exactly the
Not to
question.
my
you asked. Would
no.
you ask that question again?
Yes, so
Okay.
all of
And
the
if you had any of
information
that, that would be
that
retained at your business
you
location
just
as well.
read, that was, it was information that you had prior to writing the Bainbridge Island.
Just 1 second,
Atlas.
Mr. Echo Counsel.
Yes.
And so the information that you just read from was given to you to help support your declaration in the temporary restraining order.
Yes, I believe the Katie Wiedemann one was to help me in the Superior Court. Or Katie Fisher, has her name is now.
Thank you.
I'm sorry, I did forget to ask you
Going back
about one thing
to the video
earlier.
that Mr.
Did you
Nelson
have
took of you
a
that is now
police
posted
report
on
made
the
against you
internet?
by one of
Yes.
your
Um,
wives or girlfriends?
Is it posted to a specific
Ex-wife, I guess.
website?
It's hosted on
19,
YouTube,
would it
but it's
be,
posted to
do
lots
you
of
have a
websites.
date,
as the one
time? I
from
mean,
YouTube.
there should be.
What
1994?
is the
That was my
name of
ex-wife,
Wife?
yes.
the link?
And I'm sorry, it wasn't actually.
I don't know
was
the
it-
exact name of it,
She went and got
but
a,
usually when
In 1994.
Rainierson posted
Correct.
it, it alludes to the
she got a
fact that I was
temporary
sweeping the
violence
restaurant
restraining order.
at the
right?
time I was being served.
Don't believe it was
So
ever any
you do
violence.
something
It
like,
was
four-year-old
just, she
loser
didn't want me
sweeping
coming to the
restaurant, served
property.
a lawsuit, things like
Well,
that.
that's what they're
Okay.
called.
Did he create something
Well,
called
domestic
Houston
might
Red
be.
Live?
Temporary.
Yes,
Just
it's a
know not to
Reddit
call it
subpage.
violence because there was no
So I read
violence.
it, the subreddit.
And is that
Okay.
still up today?
Um,
It is.
And do you have anything to do
So,
with that?
actually,
No,
you can
that's all
look at
Richard Lee
Defense
Rainierson.
Exhibit 10. It's in the book. Yeah.
Were you allowed to make posts during the state
Again,
court
has
litigation?
not been admitted.
I
Your
was.
Honor.
Is that why you posted about the same person comments that you had testified to earlier?
Yes.
And is that why you posted about not paying a racist shit?
Yes.
So when you say you're able to post during the lawsuit, do I take it that this TRO just expired at some point, it didn't get renewed or something?
The TRO was dismissed, and then the state court ruled there'd be no injunction on my free speech.
So there's a period during the lawsuit from the
Okay,
expiration of the TRO until the ultimate
So,
judgment.
have you ever seen this document before?
Yes.
Oh, yeah.
Yes.
Okay. And so,
Go ahead, Ms. Lane.
Mrs. Nelson at the time did mark the
I
box
want to move on to
saying
that bankruptcy comment about
the
Ms.
alleged
Nelson.
infliction of fear of imminent physical harm,
How
bodily
did you
injury, or
bankrupt him?
assault between family or household.
I
Do you see that?
was not ultimately responsible for bankrupting him, no.
So then why did you post that?
Bravado, or thinking that I had some small part in it.
Which
And what was
line
that
item are
small
you?
part?
It's
Uh,
the big,
The fact
Big
that
B,
I
and
had
then
been
subsection
approached
B.
by Katie Wynio and asked
B,
about Bill
And
Nelson,
And
and I
it would
told
be
her
infliction of
everything I
fear
knew.
or imminent physical
Okay, and
harm,
you
bodily
testified
injury, or assault between
earlier,
family
you
or
read from the
household members.
declaration that eventually,
I do see that
Mr.
box
Nelson was
checked,
denied
yes.
Okay.
a loan by
And
Ms.
then,
Nelson.
He was, yes.
I'm going to have you turn to Defense Exhibit
Do you
11.
know the parameters that Ms. Wynio used at her bank to approve or disapprove a loan to Mr. Nelson?
I do not.
And earlier, Mrs. Zavazny asked if you wanted Mr. Nelson punished. And you said you wanted him charged, correct?
Yes.
So have you ever seen this document
What do you mean
before?
by you wanted him charged?
I would hope that our legal justice system would work in a way that men who hurt women and children
I
face
recognize
legal
the
consequences
document.
for these actions.
So you have seen it before.
Yeah, it's been some time
And
ago,
then
yes.
earlier, you had
Okay.
also read from
Well, sure,
your
yeah.
October 2019.
So if you go down to where the handwriting starts,
Strike that. Earlier, you had testified that
You see
prior
that?
to your October 2019.
The handwriting, yes,
that
I've
you
been
had
reading it.
told
Okay, go
Mr.
ahead.
Nelson that he was going to be charged and
So her claim,
put in
yes, I've read
conflict,
this.
or demanded $50,000.
False claim, but
Why
yes, I
do you
read it.
believe Mr. Nelson was going to be charged?
well, that's fine. Asserting
The
that it's
woman I
false.
spoke to
But,
at
do
the
you know if
prosecutor's
this is in
office
the public record?
and my conversations with the police investigator and the FBI
Here on
investigator.
this public document,
And
correct?
do you know
So
who
it
you
is in the
spoke
public
with
record.
at the
You know that,
prosecutor's
right?
office?
Mhm.
I assumed
Yes.
it was Cassie
No.
Stokes
And
Yes.
why did you assume that?
because it was the phone number as
so,
a footer on her email.
You know that because it was in the public record that anyone can get access to this document, to take a look at it, right?
Yes.
And the one thing that actually was not asked you earlier
so,
today when you first talked to
I understand that you maintain it as false.
Bainbridge, Washington.
Do you
How long have
understand
you
why
lived on Bainbridge
a
Island?
third
My
party
entire
looking
life,
at
save
these
for a few years in
documents,
college.
your ex-wife
And what do
might
you do?
might
I
find
work
some
at Bruschetto, a
support for
restaurant. I'm also adjunct
accusations
faculty
that
at Edmonds
you're-
College
you've
and Seattle
engaged
Film
in,
Institute, and I have a
say,
YouTube
bad
channel.
acts as regards your
How many
family.
classes on average do you teach a year?
About 3.
False and misleading
And then why did you
statement,
start the YouTube channel?
1994.
During the pandemic,
You can make and take of it what
had
you wish
gone
in a
viral on
divorce
Twitter
proceeding.
with a thread that was explaining the
Okay, well, that
GameStop
didn't
stock
answer my
squeeze,
question.
kind of in
And
layman's
I-
terms.
Again, I understand you maintain it's false,
And
and I'm,
I was
it's not
asked
my job,
to
and
be
I'm not here
interviewed
to
by a gentleman in Northern
Sure.
Ireland who had a
Who's telling the
podcast
truth?
to sort
Maybe
of
one of you.
go over
I
that
don't
Twitter
know. No.
thread
You
again.
might, but.
And that went super viral.
My question really is
And
just
I was
about
invited to a couple more
that
podcasts.
do you
which also
acknowledge
went
that
viral,
some
and
third
somebody
party who
ultimately,
doesn't know either you
who
or your
enjoyed
ex-wife
hearing me talk, asked me to
could
make my own YouTube channel.
take
So I
from
did.
it that at the very
And,
least, there was a potential
Great way
possibility
to
that you were
connect with
engaged
people
in violent
when locked
behavior
at
with
home
your
during
family.
COVID, and allowed me to discuss topics that interest me.
Assumed,
Okay,
yes.
so
That's
the
not what I asked.
videos that went
That
viral, they were on
take
topics
from
you
it
have
that
not.
there's at least a
Yes.
basis for that.
And what is the name of your YouTube channel?
Don't look
Houston,
at
we
the
have a problem.
council. They don't get to direct
Do
you.
you have a
Right?
mission statement for that channel?
When it's a false and
yes.
misleading
More
statement,
Again,
question?
Mr.
Did I answer?
you
Nelson,
can make of it
Ask,
what you wish.
that is, your-
Did we create society to make
Please
everyone's
answer
lives
my
better,
question.
or did we create society to
whether or
maximize
not it
profit
is a
and drive
false or
revenue?
misleading statement
I
in
believe
your
in
format
Somebody, yes.
is not relevant.
And what was your purpose to start the
Stop talking
YouTube
over each
channel?
other. Go ahead, Ms. Hewlett.
Originally, it was sort of
Your assertion or
identify
belief that it is
problems
false
in
is not
society
relevant to
and
the
then
question
address
I asked. What I
ways
asked
we can
is,
fix those
again,
problems.
a
things like
third party who doesn't know
healthcare
you
or
or
criminal
your
justice
ex-wife,
or mental health,
whether or
things
not
like
they
that.
can look at
Okay, what makes you think
and
you have the
reach
answer to
a
society's problem?
reasonable conclusion that there may be some
It's not so much that
veracity to accusations.
I think I have the
that you
answer any more than
engaged
anyone else
in
does,
Violent behavior
but
towards your family.
it's a way
That's all. Not whether it's true.
that we
They
can
could believe it, yes.
sort
Okay.
of flush out
All I wanted to
the problems, the systemic ones, and sort of the,
Yes.
I guess you'd say the symptoms of them and how we can fix them.
So why does your answer matter?
Sometimes I have an answer, and sometimes it's a great way to,
Sorry.
someone else might have
Right in
one,
front of
and
you.
we can discuss it.
Microphone.
So what brings you
Can
here
quickly
today,
turn
sitting on the stand?
Page 5.
Ultimately, the
Defendant's
lawsuit
exhibit.
Bill Nelson brought against me in Superior Court.
Did
Did anybody else sue you?
Yes,
Who was that?
John DeWars.
And what happened in that case?
Originally, he filed a temporary restraining order, same as Bill Nelson, in the Bainbridge Island Municipal Court. And at that hearing, his restraining order was denied. And then 2 years later, he sued me for defamation in
Ready?
Kitsap County Superior Court.
All right.
And that case was dismissed, and I signed a
So I'm
confidential
assuming you've
settlement
seen this
agreement.
article and read it.
Can you walk me through
Years
how the
ago.
Bainbridge
Yeah.
Island bad list came about?
Okay. So,
Well,
I realized
in
you didn't
September,
contribute
October
to this, and it was,
2018,
you know, done by
was
a
when
reporter,
the Brett Kavanaugh
but,
hearing was happening in the
is
Senate.
the timeline and the
And
general
15 Blasey Ford
description here
was
made
being
of what
criticized
happened
for
with
coming
this
forward
development,
35 years after the fact.
accurate?
from when she claimed Brett Kavanaugh had assaulted her. And people were asking, well, why'd
No.
she wait so long, et cetera.
Okay.
And I
what
had
is
an example
inaccurate?
of an incident I knew about where a woman escaped her rapist, ran next door to the neighbors. They helped her,
First
called the
paragraph,
police. When the police came,
2006,
chatted with her
developed by
rapist, and
Nelson.
nothing ever happened.
Okay, on
And I
page
wanted to
2.
demonstrate
Yes.
that it doesn't matter if you wait 35
Performed
years.
a $1 million
or if you report
remodel
it
of the
the
Crumbling
moment it happens.
Manor House.
Oftentimes, the criminal justice system
mean,
will fail you. Will fail you.
Did start that, but the dollar figure
Under
is
that
incorrect.
post I made, numerous
Okay.
women were responding that similar instances had happened to them. They had
2006,
similar
his acreage
awful experiences with the criminal
dissolved by
justice
2
system
acres.
and seeking justice. Ultimately, people asked who the man I was talking about.
Giant project
Said it
is
was Bill
halted as
Nelson.
recession
From that
hits.
point forward, people
Project
then started
Bank,
talking
City
about
Bank
their
of
own
Linwood
experiences with Bill
fails.
Nelson.
And Nelson no longer can
how
draw
terrible he
loans.
is.
Almost 1 million
And
liens are filed by
It led from there,
subcontractors.
such as,
There was
then
actually
I got
500 million.
messages like from
Or
Jerry Willett
500,000.
confirming incidents as
About
well.
$1 million,
Um,
just for the sake of accuracy.
That is
The Board of
juxtaposed with
Development
another
reverts
incident that
back
happened
to
on
the
Bainbridge
bank,
around
now
the same
Whidbey
time,
Island Bank,
where a man assaulted a teenager at a coffee
assumed the
bar.
assets of Linwood Bank.
And there were comments happening on the community
Okay,
page
so
on Facebook.
the only thing you've identified
ultimately,
to me as being
I decided
wrong at this point
Enough's
is
enough, like we
some of the
can't
acreage.
keep quiet about this
and
stuff.
I think the date
So
on
I created the
something.
Bainbridge Island Bad List
Accuracy.
to warn everyone about
I
these
get
men who
that.
get away with these things.
That's what
in
I
our
asked you
community.
for.
And did you
And you said
yourself
it wasn't $1 million in liens, it was 500.
actually
Those are the
experience,
items that are probably,
and
that
did
are
you, I'm sorry,
inaccurate.
strike that. Did you yourself
Right.
see
Correct.
Mr.
Okay.
Nelson
But
doing
overall,
anything that you
Other than those
posted?
items, this article is an accurate
Yes.
timeline
Um,
of,
When I
What
was a
happened
child,
with
I lived in the
development
Olympian
and then,
condominium, and Ginger Larson, who became Nelson's wife,
how the development
lived
played
upstairs
out
with
and
the
how.
children from us.
By and large.
His daughter Audrey was
Yeah.
my best friend.
Okay,
When Nelson started dating
all right.
Ginger,
Thank you.
my mom said I was no
I think
longer
that's it for
allowed
now.
to go to Audrey's house anymore. That she was allowed to come to our house, but I couldn't go over there anymore, and that was due
Do
to
we-
abuse.
Sorry, right. I know you wanted to break for
Audrey and her
lunch for a
family were
minute. Can we
experiencing.
at least take a like,
Um,
10-minute
later,
bathroom break?
When I was in high school,
So
I
we'll
was
be
at a party at the
recessed till
facilities.
11:25.
And at house party, and Mr. Nelson arrived with cocaine and tried to force himself on an unconscious girl who was asleep on a couch when myself and other boys who were in attendance forced him out of there.
May
Did you
proceed.
create a
Thank you.
mission statement
Your
for
Honor.
Bainbridge Island Bad List?
I did.
Realized that I forgot
What
to ask
was
Mr.
that
Nelson
mission
just a couple of questions.
It was
So it really will be
here
just
at the
like.
Bainbridge Island Bad List. Our goal is to let you know who the worst of our
Mr.
neighbors
Nelson,
are.
if you'd return to the stand.
I think you should know who the rapists, abusers, and creeps are so that you can protect yourself and your loved
I'll
ones.
just remind you, you're still under oath.
Can you please turn to Exhibit D?
Sorry about that, that's what I forget. Sometimes I forget to check on my notes. So I just have a couple questions.
I need just one.
Oh, I'm sorry.
And this has already been, it's
All right, go ahead.
submitted into evidence. This is the answer.
Have you ever
that
been
you
charged
wrote
with driving under the influence?
to the complaint in Kitsap Superior?
Yes.
Correct.
How many
And
times?
this is the answer, more specifically, to the complaint that Mr.
Twice.
Nelson filed against you.
Yes.
Only 2 times?
I had negligent
If you
driving prior
can be looking
to
on
a charge
D6,
of
page 1, we're looking at line
driving
number
under the
26,
influence in 2012.
the last sentence
Or
of that
13.
paragraph.
Okay.
and then 2018.
Mr. Wade alleges that
I'm just
Mr.
gonna-
Nelson does
thank
not
you.
have enough
I'm just
positive
gonna remind you
regard
that what I
in the
asked
community
you
for his
about-
character to be
I
defamed.
thought, maybe I said it wrong, is, okay, let's start with, have you been arrested for driving under the influence?
Yes,
Okay, how many times have you been arrested? for
Turn
driving under
to D6,
Twice.
page 2.
Only twice.
my, yeah,
And
When you-
you're looking at line
when you say the
number
influence,
25. Can you read that last
I had two
sentence?
previous
Mr. Wade alleges that
infractions,
the
so
comments made under his
over
post
a
about
course
Mr.
of
Nelson
20 years,
confirms the
there's
already
been
existing
4
negative opinion of Mr. Nelson
arrests.
by the community.
Okay.
And many of the comments confirm Mr.
And
Nelson's
then
predilection for
Two
underage
of
girls
them
seeking to
were
access and
infractions,
repeated sexual
resulted in
assault.
infraction charges? Is that
negligent
correct?
driving, yes,
Okay, and those were reduced charges?
correct.
Okay, and then the two others, what were the charges in those?
And can you turn to
2012
D6,
was a
page 3?
deferred prosecution, and I went through a program for,
And
5
starting,
years.
the first sentence of the very first paragraph on that.
Did you
starting
complete it?
I
Answering
completed
the
up
allegations of
to the
paragraph
last
7
6
of the
months
hearing,
of
Mr.
my
Wade
deferred
denies that he has encouraged
prosecution
others
and
to be
then reoffended in
vindictive towards Mr.
2018.
Nelson.
Okay.
Mr. Wade alleges that he.
And then what
Oh,
happened
sorry.
in 2018 with those
Oh,
charges?
okay.
I was at the ferry dock, Coleman Dock, coming home, and we had 2 cars, my car and another car came, touched,
D6, page
Stopped.
4,
got out of the car,
line
attempted
number
to
25,
discuss
that last
the matter
sentence.
with the other,
Mr. Wade alleges
Driver.
that a large portion of the population of
The other
Jamestown
driver
already
was
hold Mr.
not
Nelson's
responding.
reputation in overwhelmingly negative light.
so I
And
drove
Mr.
on the
Nelson does
ferry.
not have a good name to tarnish.
Okay,
I was asked to come back off the ferry, and they gave me a sobriety test,
D6,
and-
number 5,
I blew a .15
looking at line number
and was arrested.
5.
and I believe you were ultimately
that
charged
the
with
sentence
hit
that
and run.
starts on
and
line
driving under
number
the
5 and
influence.
it ends
The
on
hit
line
and run
number 8.
charge was dropped.
Mr. Wade denies any
But I
damage
asked
to Mr.
you if
Nelson's
that's what you were
reputation.
charged
It's
with.
the fault of
Let's just
Mr.
stay
Wade.
focused on what I'm asking, okay?
Mr. Wade
Okay.
alleges that
All
any
right,
negative
that's what
reputation
you're
of
charged with.
consequence Mr. Nelson
And
encounters
then
is
you
due to
just
Mr.
pled to
Nelson's
the
predatory
DUI
behavior
charge, correct?
and overuse of drugs and alcohol.
You know, trying to recall
Thank you.
how we pled, but that probably could be accurate as far as the DWI charge, yes.
Okay. Thank you. And I just, on the other times you were charged, were those for being over the limit on alcohol?
No, on the first 2, no.
What were those related to?
Don't know that there was ever a determination. It's been 20 years, ma'am, I don't recall.
No, I understand, but what were you accused of being under the influence of?
I don't recall.
Okay, so have you
That is
ever
it.
used
Thank you.
illegal drugs in your lifetime?
I have,
Okay, and so could you have been under the influence of illegal drugs in those 2 infractions?
speculation,
Yes or no, please?
no.
Okay, so you did use illegal
Go ahead.
drugs, but
I
you
think you're on it.
know that you were not under the influence of those when you had the 2 earlier charges?
Mr. Wade,
One
can
of
you
the charges
try
were dropped
to
or reduced to negligent driving,
exhibit
Yes, I understand what the charges were dropped
which is
to.
erratic driving.
subsection exhibit D?
Again, that's fine, that's not what I'm asking you.
Plaintiff, yes.
I'm asking you if you're certain that you were not under the influence of illegal substances for those previous
Plaintiff's exhibit 2,
no matter what
subsection
led down to.
D.
Okay, so you used illegal substances and you never drove while under their influence,
No,
okay? So you never drove under their influence?
of alcohol I did.
Oh, okay. And by the way, what illegal substances did you use?
In the past, marijuana.
Okay. Anything else?
I had tried cocaine years ago.
This was the first
Anything else?
No,
post
Okay.
that you
So,
made about
if
Mr.
I understand you
Nelson,
correctly,
correct?
we've had
Yes.
4 DUI incidents. Various, understand they were pled down to different things, but there's been 4 incidents, correct?
And
correct.
this was prior
And
to
the
October
fir-
16th.
or the
correct?
one from 2018.
It
what
was, I
happened
believe it was
before
October
that?
4th, the date's not on here.
Went back into a 5-year, what would you call it? Probationary period,
Said
Okay.
you were
Yeah.
served with the
Is that
TRO
complete
when?
yet?
That'd been
2023.
October 24th.
what is this, 18, 19, 20? Yes, it is.
Okay.
We're still
Turning back
working on getting
to
the legal part of it done with
Appendix
DOL,
Exhibit
but yes, it's completed.
D7.
By DOL, you meant Department of License.
Yes,
Did you have your license restricted?
during that 5-year period, yes.
And so you couldn't drive at all?
No, I could drive,
Oh, you just had restrictions?
yes.
Have you ever been charged with assault?
Not to my recall, no. I don't, I mean,
Sorry, I just was.
no, I have not,
Yeah.
okay?
I might have some arrests.
Yeah, but I'm 64 years old, give me a break.
Okay, well, most people would remember, but.
Yeah,
okay.
no, I don't hit people or assault people, so no.
Okay.
Going to page 11.
I think that is, I think that answers the questions that I have. Okay, thank you very much.
Yes. Hold on one
That-
second. Your counsel may have more questions.
You're alleging is a response. I have no further questions.
No, thank
After the post that we just referred to in plaintiff's exhibit 2.
Yes.
Call
Similarly,
another witness.
Mr. Honor, I'd like to call to page
All right,
10
Mr. Wade,
of
if you come up here,
D7.
please.
So the page before, that's dated November 8th.
Yes.
Okay? And page 12, that letter
Affirm the testimony you'll give today will be-
is dated November 30th.
Yes.
All right, please have a seat.
And the email
What do you need?
on page 13, that's
Is
dated
it somebody's
December.
phone? Does somebody have a cell phone close to the mic? We're getting feedback. The last one. Push it away
Let
from
me,
the mic.
I'll repeat
Thank
that for
you.
the court, Your Honor. So
I got
the-
page 11, page 10, and then where did you go after that? And
then
I'm
we
ready when you are.
went to page 12. Mr. Wade, please state your name and spell your last name for the record.
My name is Houston Wade, last name
that-
W-A-D-E.
Letter
You use social media
is
regularly, correct?
dated
I do.
November 30th. You use Facebook,
The one
yes, Twitter, on page
page
12.
Well, yes.
You did it previously. And then moving on to page
Hold on
13,
1 second. We're still having a phone
that
issue somewhere.
email
Is your cell
is
phone?
dated
Your laptop?
That mic's on too, Ms.
December
Houston.
9th.
Can you put it on a
Yes,
chair
correct.
maybe or something? It's just creating feedback. so
Oh,
our
sure,
records
sorry.
get
Sorry.
distorted.
And
All right.
none of these, and so you said you no longer use Twitter, but none of these documents in
Yes.
the exhibit used at D7 during the course Page 10, of the trial, 11, Mr. Nelson, 12,
I had
or
it,
13, you used it after the trial as well? None of them were signed under penalty of perjury, correct?
Yes.
You used it before the trial?
They're not, but Katie Weedman did
You
fill out
also
a
have
declaration
YouTube page?
for the case later.
You do live streams on YouTube? But this
I
email
do.
is not correct. You
No.
like to engage with your audience? And in fact,
I do.
aside
questions? I
from page 11,
You enjoy the interaction?
every single one of these
I do.
was
You're
sent
the creator
after
of
you had
the
been
Bainbridge
sent
Bad
to
List?
TRO, correct?
The Bainbridge Island bad list.
You're the creator of that?
Chair Willett
Yes.
sent his before.
You left the comment function on that, on
The one,
You
did.
responded to the post? Besides
That's
11.
right. Some.
So besides 11,
Responded to questions as
page
well?
10,
I believe so, yes.
12, and 13,
But you also
all of those
posted
were
on
sent
the
to
Real
you
Bainbridge
after
calendar
the TRO.
Facebook
Yes.
page?
May have
And all of
commented on there.
them were sent, but in fact, posted because of the TRO,
In response to.
because of litigation.
Yes.
The public can see it?
Members of the Real Bainbridge Islanders could, yes.
And the
So,
members are
At the time of your first post about
members
Mr.
of the
Nelson,
Bainbridge Island community?
none of
Yes.
these corroborating claims that you're pointing to were in your possession.
And
Well, I mean, Ashley Cross
during
Road
these
commented on
posts,
the
you
posts.
allege that Mr.
corroborating that.
Nelson committed
But
domestic violence against his
Obviously,
former spouse?
your post came first.
Those aren't my allegations, those are his
Correct.
former spouse's allegations. Yes, because I'd asked some of them to send me something.
Posted that,
Yes.
correct?
So at the time of the post, you didn't have these supposed stories from individuals.
And you didn't
Oh, I had the
cite
stories, just not in a
the
written
document at
form.
the time, did you?
So, I'm sorry, you went a little fast for me. What post
And
are
you
we
didn't
talking about?
cite,
No, go back like 2 for me, would you? When you first asked it, what was the topic you were asking
Going
about?
back
you told
to
people online that Mr. Nelson committed domestic violence against his former spouse.
Exhibit
Domestic violence.
to,
You told people online that he abused his stepchildren.
I did.
I'm sorry,
You
what?
told people online that Mr. Nelson tried to kill you several times.
No, he threatened to kill me.
Objection, Your Honor. I'm objecting to this whole line of questioning.
Exhibit
We've
D,
already
within
established
that.
what he has said online, and we're only trying to get to his intent at this hearing. I need to rehash what was said.
Your Honor, we're here obviously about his intent, and all of his comments go towards that.
Yeah, I'll overrule the objection.
He told people online that Mr. Nelson conspired with the Bainbridge-bound Police Department to cover up crimes, including the running of a child sex ring.
Those were allegations made by Megan
In
Angel
this post,
and Ryan Landworth.
objection, non-responsive, you state, did you post that years ago,
Oh, I
a
posted,
connected
yes.
alcoholic Republican politician / real estate developer people online that Mr. Nelson daughter being investigated by the
escaped and ran
FBI
naked to the
for
door
engaging
of the neighbors
illegal
who
conduct,
happened to be
including the rape
another
of-
friend of mine screaming
including
for help.
for rape and child abuse.
They took her in
he
and
was,
called
yes.
the police. When the cops arrived, they shook hands with the rapist and
In
choked
fact, he
him
actually
some time.
referred to my client multiple
No
times
arrests,
as
no
a rapist
charges, no
online, correct?
taking
did,
the victim
yes.
for medical exam or rape kit, nothing.
You referred to him as a rapist. You did not during the course of the trial.
I did not observe it, no.
During the course of the
None
case,
of the
Talking about the
posts
state court case?
state court case.
or
yes.
letters that
I
you
did at least
received
once, yes.
are from a witness of this.
And you referred to him as a rapist also
And
after
this
the
claim
court
was
had
ruled
issued its final
defamation by
ruling,
Judge
correct?
Hauser, correct?
Yes,
it was.
subjective, because I did not get the final ruling
Sorry, could you go back to
for
your
months
immediate
after it
prior
was made,
question?
because I was
Basically,
in the process
two
of
back, not the
filing.
one you just asked.
And I had no
None
idea
of
that
the
there had
responsive
been
posts
a
or
case ongoing
letters
at that point.
were from witnesses of this
Of that
allegation.
action. And how did you answer?
No.
Mr. Wade,
Yes.
do you recall receiving, let me first ask you, please turn to proposed exhibit number 2 of the plaintiffs.
Your Honor, this is
Moving
not
to the second
permitted.
page.
I'm objecting to the
Following
use
page.
of this
Yes.
exhibit. All of the posts
This is the
to this
post that you identified,
exhibit
Mr. Nelson.
cannot be properly
Comments, yes.
authenticated. I objected to this.
And this is where you stated I
Wow,
worked hard to
wow,
pay for it, and
post.
finally did. Correct. Now,
The
you've claimed
our
that that's,
responses to
bravado
the
speaking?
kind of second set of requests for admissions is
So,
actually P3 on
is that your way of
the
saying that
noted in
you lied,
exhibit.
No. Embellished, maybe.
embellished? So,
Look,
you
I looked
didn't-
at both P2 and P3 after the
I wasn't one
pretrial
of
conference, and
Yeah, but you said,
I don't think it works to exclude in bulk, because some of the things he did in fact admit, and the other ones
Well,
he did not and did not
Subjective
acknowledge them
in
as
the
his.
phrasing
So,
I use.
um,
Maybe
I
hubris.
think we're really going to have to, depending on what the questioning is, we're going to maybe have to deal with it as parts of the exhibit. So I got to see where the questioning goes, but
Sure.
I would overrule the exclusion of these in bulk. I think I misspoke. I think it's 2 and 3, not 3 and 4. Yep, it's P2 and 3.
and
So let's see where this goes. Go
going
ahead.
back, Mr. Wade, first
Can you
page,
turn
still on
to
exhibit D.
exhibit
F, and the woman you're referring
Basically,
to,
a subpart
that exhibit F
supposedly
of
was raped.
plaintiff's
Who was
exhibit
that?
2.
Page 36, if you see the bottom corners.
And you never posted, either here or in any of your follow-up posts, that in
Objecting
fact
to
Mr.
this
Nelson
exhibit,
had
Your
to get a restraining
Honor.
order
We have
against
no
her. Did you?
idea
I did not post that, no.
where this
I never found a
exhibit
restraining
came from.
order
There's no
against her.
identifying markers on this
Did you
exhibit.
look?
I did.
We have no idea if it's
Yeah, I think so. Well, we'll find out when he asks the question. You can ask a
So
question.
you looked, but you didn't, you couldn't find Wade, it? do you
Yes, I
recognize
couldn't find it.
the document you were able to find in front of you?
I
Records
did.
regarding Mr. Nelson?
Yes.
Do you recognize, would you say you're good at research? From Rock God?
I'm
at
adequate.
The W.
I don't have to search
Houston?
for everything, but I can find something.
Yes. Okay. And is that your
You just
Twitter?
repeat who that
Was that,
was.
was
Last
that
name,
your
that's what
Twitter?
Oh, cult
handle?
writer. Yes.
Cult?
Yes, KALTREIDER.
Do you recall posting this, or tweeting, if you will, this
Thank you.
comment?
Yeah, looks familiar.
And what did you state?
It said, I'm not paying a rapist shit.
And this is in reference to Mr. Nelson. Did you ever do any research to
Uh,
see if
yeah,
Mr.
probably.
Nelson had ever been And you were
arrested or
responding
charged with any type
to,
of sexual assault case?
I did search as well, yes.
to a
And he had
post
not
from
been
an
arrested or
individual
charged.
that they handle,
And did you tell
Jack,
that
to
be
your
right?
followers as well?
Yes, no, the
And
entire point of the
what
article was
does
to point
Jack
out where the criminal
Wright,
justice system has failed us.
State in his or her. Did you look to see if anyone had filed a rape
He
complaint against
says,
him?
you paid off the 500,000 you
no,
owe for the guy for defamation.
So he's referring to the judgment.
Apparently at this time,
speculation?
yes,
And
but I didn't know
did
there
you
was
look to see
judgment at that time.
if anyone had
Hold on,
sued
we all
Mr.
got
Nelson
crossed.
for
You asked that question again.
sexual assault?
I did not
My
find anything on it either.
question
no.
was, he's
And so did you
referring
tell your
to
followers
the
about that as
judgment
well?
No.
against you in this case?
Looking back, that appears to be what he was referring to, yes.
Okay. And it appears at that time you knew that because you referred to Mr. Nelson in your response.
Well, he was the only one suing me for defamation.
And when was this tweet made?
It says here January 30th, 2022.
And when was the court's ruling, specifically the finding of facts, conclusions of law, and judgment and permanent injunction?
I believe that was in September of 2021.
So months prior then.
Yes.
No further questions, Your Honor. And that was for, the judgment was for $500,000, correct?
That's what I found out later, yes.
Mr. Lane, any further questions for this witness?
Yes, I do.
Okay, just 1 second, please. All right, go ahead when you're ready.
Just 1 second, Your Honor.
Yeah.
And did you say how many times you referred to my client as a rapist during the trial?
Objection. Can we get clarification on what do you mean, how many times?
Do you know how many times you referred to my client online as a rapist?
Oh, no.
Your
I
Honor,
know
we're
at
waiting
least
for counsel.
once.
Can we have it?
After I won the injunction
conclusion of
hearing in
Mr.
2019.
Yes.
Thank you.
But for the other times, I didn't use his name in a post.
So wait, how did you know of the alleged rape?
Troy Dentman told me all about it.
Who's Troy Detman?
He was the neighbor that Elizabeth Cutwater had ran into for help. And
Bainbridge
he
Island
was my roommate for a period of time.
Badness target audience was Bainbridge Island,
Sorry,
correct?
again, I'm not good
Yes.
at catching these names.
Oh,
As
Troy
was
Dentman.
the Bainbridge, excuse me,
D-
Bainbridge
T- T-
Islanders
M-A-N.
Facebook group.
That is also a community page, yes.
You've also made posts via
How
your
is it-
personal
Oh,
Facebook.
sorry.
I'm still just trying to
About
make sure I got
Mr.
your
Nelson,
answer.
I have, yes.
So you heard about it from him, and
Yes.
then what was your
And
relationship with
He,
him? or-
he was the person
In
she had
fact,
run,
the
first
first
of all, I
post
run
that
through
you
for
made
help,
about
and he was my
Nelson
roommate
was
for a period of
prior
time.
to the.
So you're saying she ran to his
Atlas
house or
Yes.
his parents' house?
It was, I
His-
didn't
his-
originally
his
use his name.
What was that?
I did not originally use his name, though.
But did you reveal it in the comments?
I did after I was asked.
When was this told to you?
This would have been probably around 2011 or so.
Not scared to say that you don't like Mr.
How was it
Nelson?
I hate
disclosed
the
that it was
guts.
Elizabeth Cultridge was the alleged
You don't want him to be
victim of rape?
successful, correct?
I don't care if he's successful, I just don't want him to hurt people anymore. Troy named her, and then
You don't want his
later,
business to do well?
This is
I don't
hearsay,
care
Your
if his
Honor.
business does well, I just don't want him to hurt people
Until
anymore.
they're trying to craft their
So when you
questions
tell
in such a
people
manner that
not to
get
give them
around
money,
it.
that's
This
not
is
relation to his
an
business.
out-of-court
He
statement.
ran for office twice. People gave him money then.
Was he running for office in
Well, it
2019?
still goes
He
to
was not, but that doesn't
Mr.
preclude him from running
Wade's
again.
state of mind.
Now, you've stated that.
Yeah, I agree. I still agree with that. I mean, I'll overrule it.
I
I
don't
don't
think
think
I do, yes.
these things really matter when we're dealing with subjective intent, so I'll let you ask the
You
question.
posted online that you worked very hard to bankrupt Mr. Nelson, and you finally did.
I did post that, yes.
And you've stated that you don't
Did
want
you
people
ever
to do
use
business with them
Elizabeth's
because
name
he hurts
in
women
any
and
of the
children.
posts?
I'm not posting that.
Objection. That's so how did her name, it's not stating what was in the post correctly.
In the original
Yeah, it's not exactly
TRO,
how I
Mr.
worded it.
Nelson named her.
So you did not name her.
Did not name her, no.
All right, I lost that a little. I'm going to sustain the objection, but just so you can answer the question again and I can get the answer, please.
So the question was, you didn't want
All right, thank you.
individuals to do business with Mr. Nelson because you claim he hurts women and children,
Any
correct?
further questions?
That's not how I worded it, no.
Very quickly, Your Honor.
Sure.
Is that not what you thought, though?
Not exactly how my
Who was the
thinking worked
individual
out.
again that allegedly told you this
Can you
story?
turn
To,
Well, two people did.
I
First
think it
one was
was
Troy
exhibit number
Detman.
12. Troy Detman.
Yes.
And he did submit a declaration in the underlying case, didn't he?
He didn't have a chance, no.
No, he didn't. Didn't have a chance?
Yeah.
Okay. But litigation was going on for how many months?
Sometime, yes. I was hoping to depose him.
Can you turn to page 47?
On the post in Exhibit D, plaintiff Exhibit 2, subsection D is in dog. And I'd like to direct your attention to line 17.
Line 17, okay.
And you were asked, although you weren't directly involved in the recession or anything, it was your understanding that you played a part in this post. Correct? Second paragraph,
I see that,
you
yes.
said years later in the middle of the night, and your response was, 13-year-old son, there was a part to play, it was because my friend Catherine Reno at the time was a commercial loan officer. Detailed, she was telling me about any development that was going on.
Yes.
So there was not any confusion. Someone had come in and asked for a loan. And I
If you
asked
knew
her
the
who it
situation,
was,
you
and she
probably
said
know
it was
exactly
Bill
what I'm
Nelson.
talking about.
And I told her about the rape and abuse that Mr. Nelson had done against people in my life and classmates of hers and mine, and she rejected the loan.
I did say that, yes.
Nothing further.
Ms. Lane, anything further?
No, Your Honor.
All right, Mr. Wade.
And this wasn't the only
Thank you.
loan under that request that
So we'll
was
take a
rejected
break
by
in
her.
just a second, but tell
that
me
was made
where
by
we
Mr.
go from
Nelson,
here.
correct?
Are we gonna
As far as I know,
recall
yes.
Mr. Does either party want to recall Mr. Nelson?
Smith, please.
Yep, go ahead.
Thank you. Sorry. I was trying to open something, sorry.
Go ahead.
Now, it's fair to say that you don't want the public to think well of Mr. Nelson.
Public already does not think well of Mr. Nelson, regardless.
Objection, non-responsive, Your Honor. Strike.
Yeah, I'll strike.
You don't want the public to think well of Mr. Nelson, do you?
All right, Mr. Sabah?
No, I don't.
All right, so anyone have any other evidence they
don't
want
want
to
him
put in,
to
or we just
have a
have
date
closing
for that.
arguments?
I don't think men who hurt women and children
Close
should
it.
go on.
Objection.
Objection, non-responsive.
All right,
Move to
then
strike.
let me give you
And sustain.
a little bit of time,
So, again,
and we have
you don't
time,
want
so
him
why
to
don't I work
even
off
have a
of you? How long of a break would you like to gather your
You want him
thoughts
to be a
and
pariah,
put together a
correct?
closing?
He is one.
Your Honor, objection, non-responsive. Move to strike.
That's fine.
All right, so I've got
You don't want him to be a-
2:25.
you want him
Why
to
don't I
be a
give you
pariah
35
on
minutes,
this
we'll be
meeting,
closing
correct?
at 3 o'clock. All right?
I'll say again, he already is one. There's nothing but my wants on that.
Objection. Move to strike, non-responsive. Yes or no?
I don't want anyone to be a pariah. Whether they are or not is not up to what I want.
Thank you.
I want people to be good people.
So is your answer, no, you don't want him to be a
No,
pariah?
I don't want anyone to be a pariah.
So you did say, though, that Mr. Nelson deserves to be alone and not in contact with anybody, correct?
Yes, because he
All
hurt
right, in
people.
closing, plaintiffs?
So isn't that making him a pariah?
That is him being a pariah. I didn't make him that way.
Thank you, Your Honor. Again, Paul Frazier for the record.
Now, the
Represent
Superior Court
plaintiff.
concluded the
Mr.
purpose for your
William Nelson.
defamation was to drive Mr. Nelson from the island, correct?
I don't have that in front of me.
If you can turn
I think
to
it's important to remember
exhibit
that
number 1.
a discharge in bankruptcy is a privilege and not a right, and it should only inure to the benefit of an honest debtor. And what we have here is a dishonest debtor. Mr. Wade has admitted under oath
Can you turn to page 3, please?
that he lied under oath.
There's 3.
And the Kitsap
Can
County
line 3 and 4?
Court
Line 3 and 4,
determines in its
Paragraph
order
3.
that
Paragraph 3,
Mr. Wade lied under oath.
It states the allegations were all false. The defendant's purpose in doing these things was to run Mr. Nelson off the island.
That's what it says, yes.
We only need to show that
So being run off the island
by a preponderance of
being
the
a
evidence,
crime
meaning that
in one's
it's more
community
probable than not,
is ultimately what you hope to
That-
achieve, though, correct?
No,
Mr. Wade
because I was never at this hearing.
must have actually known, by making
Never
these
got to defend
statements,
myself.
Objection,
Well,
strike non-responsive.
that
I'm being
injury was
controversial
substantially
in
certain to
context.
occur. We don't need to
Nelson's
establish
attorneys wrote this,
or
and the
get an
judge signed it.
unqualified admission from
Without ever
Mr. Wade.
Without my ever
if that
having
was
the
the
ability to
case,
defend myself.
Then
So
it would be
the judge
nearly
rubber stamps the
impossible
order
to
Nelson's attorneys wrote.
And
accept a debt
objection,
from discharge.
non-responsive.
I'll sustain
The
it.
willful
I mean, it doesn't
element,
matter. We're getting
the
into this
willfulness
before we
element is
step in the
satisfied when
kitchen.
the
That's
natural
what it is.
consequences of
Sorry,
the
I
debtor's
just have a
actions
limited
are
amount of time, and I'm trying to
substantially
just
certain
I understand.
to
I
cause injury.
apologize, Your Honor.
No.
And there is a presumption that the
time.
debtor knows the natural consequences of his actions. We have already established as a matter of law that the statements
It's fair
that
to
were
say that
published
being
online by
pride in
Mr.
one's
Wade
community is harmful,
were
correct?
false. We have established that they were malicious. We have
I'd say
established
being
that
a
they caused
pariah
injury.
is harmful to the community.
So we only need to establish, again, by a
It's
preponderance
not
of the
harmful
evidence,
to the individual.
that when those statements
The
were made
individual being a
online,
pariah
repeatedly,
is the
that
circumstance.
Mr. Wade should have
their
known
own
that they were
making.
substantially certain to cause injury. And again, they've already been determined to
You
be
believe
false.
Mr. Nelson should be punished?
I believe he should be charged on multiple counts, yes.
It
It
deserves to
would
be
be nearly
punished?
impossible
Yes.
for any reasonable human to
You
believe
believe in karma?
that false allegations of sexual
I would
assault
think
made
that
online
Yes or no question?
would not be
I'm not a particularly religious person.
substantially
Nor am I
certain to cause
spiritual.
injury, or would not be
I
likely to
would
cause
think the
injury.
idea of karma is comforting, but often not
And
realized.
while the only, while the story
You stated you believe when
testified
people
to
do
in
horrible
court today
things
by
to others,
Mr. Wade
that the universe
is that
eventually results in them
he
getting
was
what they deserve.
he was trying
I said that at one point,
to
yes.
protect the community and to report,
And when you were asked about this, about
claimed
karma,
bad actors on Bainbridge
You-
Island.
you thought that this
That
was the
story just
universe
doesn't hold
giving Mr. Nelson what he supposedly deserved?
Mr. Wade testified
No, it
under
was
oath
more
that
me making more people in the community aware of what he had done.
he intended to cause Mr. Nelson's bankruptcy, and in fact
Did you
testified
not
that,
think
or
that
and in fact bragged that he caused
karma,
Mr. Nelson's bankruptcy. So this had nothing to do with protecting the community. This was a targeted attack to cause and inflict as much, reputational and financial harm as Mr. Wade could possibly inflict through publishing these false allegations on social media. Now, significantly, there was not a single witness or sworn statement
if you can turn
under
to
oath
Exhibit 12,
presented
please.
by Mr. Wade to corroborate anything that he has said.
Exhibit 12.
Not one. Mr. Wade did not attempt to
Page 41,
introduce
please.
into evidence any
41,
sworn
please.
testimony by any independent witness. There was not a single exhibit admitted into evidence by
On line
Mr.
7?
Wade.
You were asked a
attempting to
statement
support
in which you
the
said
truth
that
of the
karma,
allegations that he made.
that it was karma that Mr.
All
Nelson
we have
suffered from
are
bankruptcy.
hearsay,
that directly
out-of-court
relates to the
statements,
financial harm.
not sworn under the penalty
Correct.
of perjury, and there are reasons we have rules of evidence. There's no one here to
That's the
back
question I was
up
posed to you.
anything that's been
It
said.
says, yes,
Mr.
Christine,
Wade
which
himself
said that
admitted
karma,
that
it was
he did not
karma that Mr.
find
Nelson
any
suffered from bankruptcy that
corroborating
directly caused harm,
evidence
correct. And I answered,
to
I am
support
not,
the
am I not
allegations
part
that
of
he
the
made.
universe?
He claims that, he says he is a
On line
proficient
14,
researcher online.
You stated,
He
again,
did not
I
locate
am
any
a member
criminal
of,
proceedings, any civil
I am
proceedings,
a part of the
supporting
universe.
his allegations
Yes, that's it.
of rape. Yet he states that as fact, over and over and over again, online.
And if you can turn back
What
to
this
page
was,
40.
this was a social media lynch mob designed to destroy
Line
and defame
22,
Mr. Nelson.
you testified under oath. I think that when people
none
do
of that-
horrible things to others, that the universe
That lynch
eventually
mob
results in them getting what they
Has
deserve.
never stood behind anything
Correct.
they've said.
I said that, yes.
They had, this has been in litigation
And
for
so-
5 years, since 2018. And if
You
there was
were,
anyone
in fact,
to
acting on behalf
corroborate,
of the universe.
again, any of these statements
No more so than you are
about
now.
Mr. Nelson, they had 5 years to come forward with a sworn declaration. Mr. Wade had the opportunity to depose them or to have them testify in court in his favor. And it's been 5 years of complete and utter silence. Mr. Wade admitted through
Now,
request
Mr.
for
Wade,
admissions
you were also deposed
that
in
he made all of
2019,
these
correct?
statements
I
that
was,
have been
yes.
alleged.
And as a part of that
Plaintiff's
deposition, you
exhibits
swore
number
an oath
2.
to tell the truth, correct?
I did, yes.
Just like you swore an oath today, correct?
I did, yes.
And 3
But
were
during
admitted
that
into evidence,
2019 deposition.
and
you did lie
specifically
under oath.
Exhibit B,
Objection, Your Honor. The
Exhibit
deposition
C,
is only going to impeach, or is only for impeachment purposes.
Exhibit F, and Exhibit H.
I mean, that is correct. And I don't know where you're going with this quite yet. I mean, of course, the impeachment, he's got to answer some prior question that then there's something contrary in the deposition.
Mr. Wade admitted
So
to
I'm not
posting
sure what
online.
question you're trying to impeach him with.
So there is no
Well, I
question,
haven't attempted
that
to
this
use the
stuff-
deposition yet.
and these
I know it's a
defamatory
foundation.
remarks were made.
Fair enough.
They've been
You tell the
introduced
truth,
into
and I'm not
evidence.
using the deposition.
He does
Right.
not dispute
Go
making
ahead.
them.
So
And
again,
similarly,
during the
he does
2019
not
deposition,
dispute
you lied under oath, didn't
the
you?
damage that they caused.
That
Again,
is what you accused me of, yes.
Mr. Wade concedes and admits that he was
Did the court also determine that?
targeting
Of course,
Mr.
yes.
Nelson, that he loathes Mr. Nelson, that he hates Mr. Nelson, and that he was purposefully intending to
You
injure
claimed
Mr.
under
Nelson.
oath that
There is
you
no
were
dispute
exchanging
about that.
emails with the county prosecutor.
And
Um,
this is
I
all
don't have it in
stemming
front of me,
from, and I'll quote the Superior Court,
May I go through a
Wild-
timeline of events?
allegations
No.
that have no basis
So-
in reality.
I had email exchanges and I had a phone call to the prosecutor's office.
So when you
yes.
make wild allegations that have no basis in
Under oath, you were
reality,
asked if you had any communication
Online.
with that prosecutor a week prior
Repeatedly.
to, you
about
testified you had
accusing someone, falsely accusing someone of
communication
sexual
with the
assault.
prosecutor a week prior, within a week of the deposition, correct?
I did, yes.
It's
But
more
this was not
probable
true,
than
was
not
it?
that that is substantially certain to cause injury.
I don't know how to answer that correctly because the line of questioning.
And again, there's no
I think
dispute
back
that
to it,
these
I
allegations
think
were
was
made.
interpreted wrong.
There's no dispute that
you
Mr.
had
Wade
asked
made
my
them.
proposal-
Objection, non-responsive, it's a yes, no question.
It's
And
not
even
a yes or no
in his
question.
deposition,
You can respond.
Okay.
he talked about
Because I
karma,
think in that deposition,
And
you
about
had asked
karma
if I'd
being
spoken to anyone
part
from
of the
the office, and I
universe.
said yes.
coming
And then you
back
asked about
to
emails, and I said
you know,
I had emailed with them. I don't think it was
exact
specifically about
retribution
Nelson at that time. It had been about
and pay
John
people
DeWitt
back for, alleged wrongdoing.
back then.
And Mr.
Can you turn
Nelson,
to
or Mr.
Exhibit
Wade,
6, please.
he believes he is the universe. That's what he stated in his deposition. I mean, his Twitter handle is RockDog. And he stated that, he thinks he has the answers to cure all of society's ills. So he himself believes that he is
Page 133.
he is like a god, essentially. He is out here to exact punishment on individuals who he himself, believes should be punished. And that's what he was attempting to do here. This was not about the community.
Go backwards.
This was about the community. These would have
130
been
what? Sorry?
objective facts
Page 130.
supported by actual evidence,
Let's do 131.
not
That's-
wholly uncorroborated again, wild allegations that have
Line of
no
questioning
basis in
regarding
fact.
this is done.
And I think we've probably all read the news enough to know
So
that
131 of
wild
the
allegations
deposition.
of sexual assault
there?
that have no
Yes.
basis in reality actually do more harm than
And
good.
you asked, line one. Line
They
one.
don't help the community.
Have you spoken to the Kitsap County
In fact,
Prosecutor's
all they do
Office?
is tend to undermine what
Your answer was-
actual victims
Oh,
of
I'm sorry, I'm
sexual
looking at the wrong
assault
131. I'm looking
are
at the right
trying,
one.
are trying to
That little one up
accomplish,
top,
which
right.
is to have someone believe them. So
Yes.
any claim that
You're
Mr.
there now?
Wade
Yes.
was attempting to,
And so you
help
asked,
the
have you
community
spoken to the Kitsap County Prosecutor's
Uh,
Office?
is
And your response
simply
was-
not true.
I have.
And it cannot be true
And
as a matter of law, based
When-
on the
and then I
findings and
asked,
facts.
when did you
and
speak
conclusions
with
of
them?
law in the Superior
this
Court
week.
judgment.
Okay.
So again, the low burden of proof here is a preponderance of the evidence. It's whether or not the debtors actually knew that injury was substantially certain to occur.
And on page 132,
And it is
Yes.
more probable than not that wild allegations
On line
of sexual
two?
assault have no basis in reality.
question posed to you.
Repeatedly
When-
published on social media.
How did you communicate with her?
Would tend to
I
cause,
believe
or would be
before they
substantially
asked
certain
me
to cause
about
injury.
email,
And for that
so I
reason,
said, yes, I had communicated with
Your
email.
Honor, we ask that Your Honor find that this debt be
And so your answer to that
accepted
question
from
was
discharge
email.
Yeah.
for willful and malicious injury.
And on line 4, I asked you regarding
Well,
divorce
thank you.
or regarding
Thank you, Your Honor.
Nelson or both?
I said DeWars originally, Nelson recently, but before they'd asked me if I'd spoken with anybody at the county, and I said yes.
And the question number 7, you exchanged
Defendants?
emails with her?
Yes, I'd exchanged emails with her.
Thank you.
And scroll down to line 22.
My computer will die on me.
I asked you, when did this take place?
When did I speak to them? I said it was this week.
The email. We can go line by line.
I know, but this is where the confusion, I think, came in with my answering.
Let's go down the line, so
Okay.
maybe it's not.
Originally, you asked me, did I speak with anybody at the prosecutor's office? I said yes. An email is not speaking, an email is written communication. So if you're asking me about when I spoke to someone versus when I
Wade
emailed
can't
someone,
support
the way
any
your
attack
questions
on the
go
facts
in this
because
line
the very order
seems to be
that
where I
they
got
have argued
confused. And that
successfully
you're
is-
asking if I spoke to someone or if I emailed with someone.
This court has made that
Let's
clear.
review this declaration,
But
or excuse me,
now-
deposition. So,
We are
again,
here-
question 7. I
For-
asked you,
to
you exchanged
discuss-
emails with her. Your answer was
One little
yes,
prong
yes.
of 522,
I then asked you,
523A6.
which email address were you using? Your
Here are the
response was
facts.
the Kitsap County.
Mr. Wade
Gov-
testified that Mr. Nelson
Yes, Your Honor.
personally took video
I
of
then
a
asked
process
you, your email
server
address. Your response
serving
was,
Mr.
oh,
Wade and Mr. Reinerson got the
Question
video.
to you,
But
which
under
email
oath,
address?
Nelson said he
Oh,
doesn't have any
HoustonWade@gmail.com.
meaningful relationship with
Yes.
Mr.
I
Reinerson.
responded, I'm sorry,
Except
which
for
one?
encouraging email.
HoustonWade@gmail. You want to
Nelson
use for
said-
everything.
Yes.
Objection, Your Honor.
Wade
This
made these
seems more like
accusations out of
testimony. Is
thin
there
air.
a question?
But Nelson
Your Honor,
testified he
Mr. Wade
was
is
charged with
testifying
4
that
DUIs,
there was some
including a
confusion
hit
in
and
this
run.
interaction.
And his
So we need
ex-wife
to go
filed
through
a
this
domestic
testimony.
violence
Go ahead.
restraining order and made specific allegations of
Continue.
violence and threats against Mr. Nelson.
And the question was asked?
This is
and you
all
said it
public
was
record.
with the
It happened
Kitsap
prior
County
to the Bainbridge
interrupted-
Island bad list.
Yeah,
He also testified his
Then
4th
prosecutor's
DUI was in
office.
2018.
yeah.
Mr. Wade testified he witnessed a
And then
sexual
asked,
assault by
when did
Mr.
this take
Nelson
place?
years prior to the Bainbridge Island
His
bad
response
list
is
being
this
created.
week.
That's
And
when I
this is
told him,
unrefuted. Mr. Nelson admitted
But
the
all
use of
prior
cocaine.
questions were regarding.
Let's remember he supposedly
Exchange of
doesn't
emails.
remember
No,
which
the first
substance he
question
was
we asked,
under
I
when
spoke
charged with his first 2 DUIs. When Ms. Hulsman asked if he was ever arrested for assault, Nelson said he couldn't recollect. While I'm pointing out problems with the truth Mr. Nelson had on the stand, we're here today to determine Mr. Wade's subjective intent. A dishonest debtor
And
relates
do you
to a
recall,
debtor that has lied on their
Prior to the
schedule.
deposition beginning, that
Wade is
you
not a dishonest
stated to my
debtor.
client
The
that
basis for Mr. Wade's
my
beliefs
client
are
was
substantiated
going to
here.
be charged with
Nelson
felony,
testified that some
witness
of the
tampering
negative
if he
comments
didn't
on the
dismiss case
October
and
4th
pay you
post, which is
$50,000.
Defendant's
I
Exhibit
said I was
2,
going to have him
are
charged, yes.
people he knows.
And you also made
The
a
only
demand for
evidence the plaintiff
$50,000.
has submitted
Yes,
is
for
their
legal costs.
Exhibit P1, the findings
And at
of
this time,
facts
you
and
were
conclusions of
representing
law
yourself,
that
correct?
Wade's
Yes.
intent was to run Nelson off the island. Nelson testified he is still living on Bainbridge Island and still has his business there. Nelson also
And it
testified
was
that he
these
was scared to go
statements
in public
regarding,
after the Bainbridge Island
your
post.
Communications with the prosecutor's office.
However, he
that
went out
was
in public
concluded
and
to
filmed
be,
Mr. Wade on October
a willing
25th.
and knowing
And this is
lie under
unrefuted.
oath by
And
Judge Hauser,
submitted
correct?
that video to Mr. Reinerson to post for him.
Well, that's what
However,
Hauser
Nelson
ruled,
acted
yes.
on the stand that he barely knew Mr. Reinerson. Nowhere did Wade say he published the statements with the intent to harm Nelson. Wade has maintained through the state court in this action his intent was to protect the community. This is reiterated in Wade's answer to the state court complaint.
Now,
This
there
is
were,
Exhibit D6.
you
This is in
received,
line with the mission statement for the Bainbridge Island bad list
Strike
that
that.
Wade testified to on the stand to protect yourself and your loved ones with knowledge. Nelson's reputation is a -1. This again is unrefuted. His reputation did not become negative because of Wade's comments. It's quite the opposite. Many people in the community already had a negative view of Nelson prior to any of the posts Wade made. Putting it simply, Your Honor, the plaintiffs have not met their burden. Thank you.
All right, thank you. All right, so that will conclude the trial. Record is closed. And so I just need to check with your schedules and set a time to rule. It can all be telephonic, because I'll be the only one talking that day, but your clients are welcome to call in addition to the lawyers. And so let's find a time in the not-too-distant future to do this. I need a little bit of time to prepare. How would September 29th work for the parties? Either at 11:30 or in the afternoon?
11:30 worked really well for me. I figured out it's nap time.
All right.
Mr. Wade,
Yes.
you turn to Exhibit 2, please.
Exhibit 2.
Probably end up being here. If you're available. Yeah.
As long as at least one of you.
Yes.
I need at least one.
Look at Exhibit 2.
11:30.
They're kind of coupled together, so
All
I
right, let's
apologize
do that.
for.
You know, and it'll eventually be on the docket, probably by the end of the
Do
day.
you
if wanna go
recognize
back and listen
what
to
Exhibit
it.
2 is?
So let's
one
set,
of the,
the trial will be set for September 29th.
admissions or
at
interrogatories.
11:30. My guess is it
And
won't
do you
take
recognize
in
what Exhibit
no more
3
than
is?
30 minutes probably, just for your planning purposes. If for any reason I'm not
Get another
ready
set of
to
requests of
go,
admissions, yes.
I'll have my chambers give you a call a couple days ahead of time and we'll reschedule, but I fully
So let's
anticipate
specifically look
that I
on
will be ready to rule.
Exhibit
So,
3. This is your response
We'll enter a docket
to
entry indicating
the
that the court will
inter-
issue its ruling September
excuse me, request
29th
for
at
admission.
11:30. And just a day or two before, if you want to
Is that
call
correct?
chambers to make sure you have
looks like yes.
the current
And
proper phone
so
information. We can
Exhibit
change the
3
passcode
is
pretty
your
often.
response, and Exhibit
And
2
with that, we'll wrap up
is
today. I want to
the
thank
complete,
everyone. I thought everyone
request.
acted professionally
Yes.
in what can be a stressful environment, particularly considering the subject matter of some of the testimony today. So I appreciate that from everyone.
And if you can turn
Now we
to
will be at
page
recess.
19 of Exhibit 3, please.
All right.
Oh, there's numbers. Okay.
Looking on line 9.
Where my signature is?
Yes, that's your, no, that's going to be my question. That's
Okay.
your signature?
Yes.
Okay. So you signed the verification under the penalty of perjury that you had read the foregoing objections and answers and responses to plaintiff William Nelson's second set of requests typo for admission to defendant. Know the contents thereof and believe the same to be true and completed.
Yes.
Yes. Okay. And your responses in Exhibit 3 are the responses to the questions posed in Exhibit 2, correct?
Yes.
Your Honor, we ask that Exhibit 2 and 3 be entered.
And Your Honor, I'm objecting based on all of the objections that I've actually listed in Exhibit 3. Some of these cannot be authenticated.
But isn't that demonstrated by your answers to those? I mean, you've said in some of your answers which ones aren't authentic or can't be authenticated, and so why is that a basis for not admitting the exhibit? If he answers a question the same way he answered it, he's going to say, I don't know what that is, I don't think it's authentic, I didn't post it. He's going to presumably say the same things he said in his answers. So why would it, under what basis would it be excluded?
This is the best evidence. Under the best evidence rule, at least the original needs to be produced, or you need to have somebody who has done the original testify that is the original document and that is a correct copy of the original document. We don't have that here. Some of these posts are not even they're comments to other posts.
Right, but that's how he responds, right? If the question is asked. If I attach a cartoon to a request for admission and you deny it, it's not, evident against your client in any way. I mean, you've raised all these reasons why you didn't admit or deny certain of these things. Presumably, he will testify consistently with that.
Okay.
So yeah, I don't see a best evidence issue here. I'll overrule the objection.
Okay.
Can you turn to Exhibit 2, please? And then within Exhibit 2, Exhibit B, he's a boy. If you can turn to the second page, the one where there's a picture, please.
Yes.
Okay. Do you recognize this?
I do.
Is this a post? First of all, did you post this?
I did.
Okay. And this is your Facebook account?
It is.
And this was posted after the injunction hearing, correct?
Yes.
So while the case was pending?
Yes.
Yes. And the contents of it, I just won the injunction hearing, which means I can write this. William Bill T. Nelson rapes women and abuses children. He's a drunk and a cokehead and is currently facing multiple DUIs and a hit and run. He's a terrible human being, and everyone on earth should avoid him at all costs. Time's up, douchebags of the world. That's
what I wrote, yes.
what you wrote. Okay. If you can turn to Exhibit C, Season Cat. And the third page on that, it's the Twitter post from quote-unquote Rock God.
That's, I'm sorry, the letter again?
Season Cat,
Okay.
the third page. Do you recognize this tweet?
I do.
The handle of the tweeter, if you will, or however we want to refer to Twitter now, is at the Houston Wade. Is that correct?
No, it's at the Wooston.
The Houston. My apologies. The Houston Wade. Is that, or was that your Twitter?
Yes,
Okay. So you were the one that was writing this?
yes.
Okay. And so you tweeted this tweet, correct?
I did, yes.
Okay. And this was tweeted on January 5th of 2019, correct?
I don't know about the date because it doesn't say date on here.
I'm sorry. The copy I have in front of me has the date,
Exhibit C, oh, page 3.
page 3.
Page 3, oh, I was looking at the wrong one, I'm sorry.
Sure, not a problem.
This is the Houston Wade one, yes.
And so, to be clear for the record, the tweet I'm referring to is, I created the Bainbridge Island ad list to spotlight these creeps in my community, currently being sued for $5 million by a pissed off rapist. He's going to lose.
Yes,
And that was tweeted on January 5th of 2019.
yes.
And again, this was tweeted during the course of litigation.
It was a reply to someone, yes.
Can you turn to Exhibit D, D's and Dog? Can you turn to page 2, please?
Okay.
Do you recognize this, this post?
Yes,
And this was on your personal Facebook page?
it was, yes.
And do you recognize the post specifically from Houston Wade? Yep, Bill Nelson, I worked hard to bankrupt him and finally did. We got the Manor House declared a historic landmark and managed to keep banks from lending to him for years. So when he finally began construction at Pleasant Beach, it was right before the bottom fell out of the economy. He needed to spend millions renovating the Manor House before he was allowed to start building the rest of the development. Do you recognize that?
I do.
Was this a post made by you?
It was made by me, yes.
Let me turn to Exhibit H. H is in Houston.
Okay.
Are you there?
Yes.
Okay. Do you recognize your post on this page?
Yes.
And this was posted on the Real Bainbridge Islanders Facebook group?
It appears so, yes.
And in response to a question from Matt McCullough, you stated it's more talking about a child sex trafficking ring in a public forum and keeping the community aware that these men also drugged and raped dozens, if not hundreds of women and never faced consequences for it. Plus, the litigation isn't long for this world since Nelson keeps threatening witnesses. And then in parentheses, you write felonies.
Yes, but Nelson was threatening witnesses.
Mr. Nelson, excuse me, Mr. Wade, you are currently obviously filing for bankruptcy at this time, correct?
Yes.
Okay. Filing for bankruptcy is not good for the individual who files it, correct?
As far as I know, it is not a good thing to have happen now.
It's harmful to them, right?
I mean, it's an inconvenience.
You don't think it's, filing for bankruptcy is harmful for you?
Objection argumentative.
You can answer, overruled.
I mean, it is what it is. I'm not a big user of credit to begin with. So, until this order came about, my discovery of it, my bank account being drawn, I was okay with paying my bills. So
bankruptcy does harm your credit?
well, obviously harm your credit, yes.
Okay. And it harms your ability to obtain loans?
Yes, if I needed some, yeah.
Sure. And you testified that you worked hard to bankrupt Mr. Nelson.
I wrote in a post that I did, yes.
Yes. And so, obviously, that would impact Mr. Nelson's ability to get loans.
Objection, Your Honor. This is asking for an expert opinion. He's not an expert on how bankruptcy affects somebody after filing.
Your Honor, he just testified moments ago.
He did.
It will impact ability to
Overruled.
obtain a loan.
Yeah, he did testify to that.
Oh, in fact, my ability to get one, yes.
No further questions at this time.
All right. I've got 12:30, and this seems like a natural break, so why don't we take our lunch break now? Let me get a feel for how much longer you think you're going to be, because I don't want to run you out of time. So, Ms. Lane or Ms. Hildman, how long roughly do you think you'll be with Mr. Wade?
Ms. Lane is going to do that.
Okay.
Yeah, an hour at most.
All right. Then I don't think we're going to have a lot of time issues. So is an hour for lunch good for everyone?
Yeah, that's good.
All right. It's 12:30. Then we'll be at recess until 1:30.
All right.
Emailing.
Yeah, is that safe?
All right, any preliminary matters before we start? No? All right, Mr. Wade, you can return to the stand if you would. Just remind you, you're still under oath. Yes, sir. I'm ready, thank you.
All right, good afternoon, Mr. Wade. I would like to go back to Plaintiff's Exhibit 2, Exhibit F, as in Frank.
Yes.
When did you find out about the state court's judgment?
That was in February 2022.
And Exhibit F, if you can look, what is the date on that?
January 30th, 2022.
So you found out about the state court judgment after you had written this post?
Yes.
When you found out about the judgment, did you take down the posts about Mr. Nelson?
I did. Or at least everyone I could find.
And when did you take down the October 4th and the October 21st post about Mr. Nelson?
When I got served for the temporary restraining order.
And when did you get served the restraining order?
That was October 24th, 2018.
And was Mr. Nelson there?
Not the original service, no.
When was he there?
The next day, he attempted to serve me again so he could videotape me being served at work. And then he gave that videotape to Richard Lee Reinierson to post on YouTube.
And then what happened with that video?
Richard Lee Reinierson posts it constantly on Reddit, Twitter, Facebook, and other social media platforms.
And so Mr. Reinierson was not there.
He was not.
It was Mr. Nelson who took that video.
Yes, and he was with the man who served me, yes.
And is that video still up?
It is.
And has
So, Ms.
Mr.
Singh, can I interrupt you for 1 second?
Yes.
What, the October 24th, 2018, what happened on that day?
That's when I was originally
was-
served.
With what?
The temporary restraining order, Bainbridge Police served me.
And the judgment is from what?
So,
Yeah, I'm not following the timeline, and this might be
Okay, so-
important, so I need to get clear on what we're talking about here.
Sure, so would you like me to ask some questions or just explain it?
Why don't you explain it to me first
Okay.
without adding anything new, if you could?
Sure, so-
And if not, then we'll ask him some more questions.
Original post that the state court litigation was about was his personal post at October 4th.
Of
And then-
18, right?
Of
Yeah.
2018, and then on October 21st one of 2000, that was the one on the Bainbridge Island address. And then he was served with a temporary restraining order by Mr. Nelson,
Or by the Bainbridge Police.
by the Bainbridge Police on October 24th.
To what? Take down the same stuff that became the basis for the judgment?
Correct.
All right.
It was just a few.
Yeah, it was just a temporary restraining order to take that down.
It didn't have specifics at that point. Don't believe, right?
All right, well, go ahead.
Yeah.
Just maybe maybe go back through that questioning if
And then
you think
you-
it's important, because I'm not sure I have everything clear on that.
Okay. Let me say it.
Yeah.
Okay, so we're at October 24th. Then what he was just testifying about took place on October 25th, which is when Mr. Nelson was,
Served me the papers again.
well, a process server did.
Yeah, process server did. And
Served in the TRO.
Yeah.
Correct.
That's what's
Yeah.
being served.
Yes, yes, right. Sorry, I was trying to say it without embellishing.
And did you go to court for the temporary restraining order?
Twice. First time, Nelson had gotten Brett as his attorney. Brett said he needed more time and asked for continuance. Then went back a second time, and this time they asked for the temporary restraining order to be dismissed and serve me with the lawsuit. Because that's Superior Court.
And in that temporary restraining order, you had filed a declaration, correct?
I can't remember if I think the declaration was filed against the lawsuit.
Okay. Can you
I
turn
can't
to
remember
page
exactly.
D7?
Oh, yeah, this is there was an injunction restraining order hearing in the county court that replaced the municipal court one.
Okay, so just to clarify, the TRO that was served to you on October 24th was dropped.
It was dropped, yes, and replaced with the county suit, the state suit in the county court.
Okay. And D7, you see the title, can you read the title of this document?
Declaration against motion for temporary restraining order, temporary injunction.
And you wrote this.
I did, yes.
Can you turn to page 7? And we're looking at paragraph 20, which is on line 19.
Okay. Would you like me to read it?
Yes, can you please read that?
I created the Bambridge Island Bad List as a news page to inform the community of who the predators are among us, and Mr. Nelson fits that bill to a T. I didn't stalk Mr. Nelson, I didn't harass him, I wrote an article about his predatory actions, which were confirmed by many, many sources. My goal is to warn people, especially young girls, to stay away from Mr. Nelson for their own safety. The purpose of journalism is to expose abuse, and that is exactly what I've done in this instance, the abuse of women and girls and the abuse of the system designed to serve and protect them.
You'll see at the bottom of these pages, you'll see like D7 in the left-hand
Yes.
corner, and in the middle of the page, you see a page number. Can you turn to page 10 of D7?
Yes.
I mean, this was an exhibit admitted into court, correct?
Yes.
Okay, and this is an email from Ashley Cross DeGrow. You see that in the left-hand corner?
Yes.
Could you please read her email?
Yes, Houston, there are a few stories.
Objection, Your Honor, this is hearsay.
This goes to defendant's state of mind of why he actually created the Bainbridge Island Bad List. We're not stating whether or not what he wrote about is true or false. We're going directly to what the state of mind of Mr. Wade was when he created the Bad List.
If he wants to testify as to his state of mind, that's fine, but
Just hold on one second if you want. Yeah, I'll overrule the objection. I think it's fine. We're talking about his subjective intent here, and it doesn't really matter what the content of this is true or not necessarily. It's the information that he had at the time, whether it was true or not, could be relevant to his intent. So not allowing it for the truth of the matter, but I will allow it.
Mr. Wade, you can please read.
Okay. Houston, here are a few stories I could think of. I hope they help. Bill Nelson is a creep. I met him when I was probably around 13 on a job site with my dad. I was one of the few girls my age that already developed a sizable chest. I was regularly mistaken for 16 at the time, which old creepy men seemed to find acceptable age to hit on me. I remember Bill clearly looking down my shirt, my dad saying something to him like, "Hey, that's my child." My poor dad had no idea what to do with me other than to warn me. Afterwards in the truck on the way home, my dad said to me very seriously, "Stay away from Bill." I've heard my dad say this quite a few times. I'm sure my dad has seen many things happen with Bill. They went to high school together, and I've never heard a good story about him from my dad. I've had quite a few experiences with Bill, and I really can't recall any of them being good. On multiple occasions, I've encountered Bill at the coop, and he shamelessly hit on me, touched me without consent. I can pretty clearly remember one specific time he touched me without asking. There was a resurgence of partying at the chicken coop at some point. This time he clearly grabbed my butt, and his son almost got into a physical fight with him about it. He tried to play it off that we were in a small space, his hand grazed my butt, but at his height, he would have to bend over a fair amount to even get close. On another occasion, he brought a date to my friend's house. We headed over to Bremerton on the boat for dinner. The whole night, he was practically forcing drinks down our throat. It made me, and obviously her, very uncomfortable. She obviously was not having a good time, and he was pushing and pushing her. She miraculously made it back to my friends without puking off the boat, but did so as soon as we got back. My friend insisted they stay the night, and she just wanted to get away from him. I don't know what ended up happening to her that night, but based on how he was touching her and giving her even more alcohol, anyone could have guessed what happened after I left.
Thank you. And Ashley Cross-DeBroche, she also made a post, or comment, to your October 4th post.
She did.
And can you turn to page D7, D711?
Yes.
And what is this?
This is,
Same objection. This is hearsay. We have no way to authenticate what this is, where it came from.
No, we can't even see who this document's from, at least in the copy that we have.
This is also going to the state of mind of Mr. Wade. This was already admitted in
Well,
this.
it is, but he's going to have to be able to at least authenticate it and tell us what it is first, because it's not clear from just looking at it. So if he's able to do that, then I would agree with what I said on the prior objection, but you're going to need to start with some foundation on this one.
this is
Let her ask you a question.
Okay. And do you recognize this document?
I do.
And what is this?
This is a direct message on Facebook from Jared Willett.
Same objection.
To myself, to me.
There's nothing on this exhibit to identify where it came from, who wrote it, or anything.
No, I'll overrule it. I think you can put it in. He's testifying to it.
What's that? If you can just rephrase, who was
So,
this from again?
it's from Jared Willett, a friend of mine's direct message on Facebook.
Can you spell that?
Oh, goodness.
Or at least phonetically or something? Is it a W?
It's
Willett?
O-O-O-U, I think E-L-E-T-T-E.
All right, close enough.
I could be really wrong on that. It's French. I don't know.
And can you please read?
He sent me a message that says, "Glad the coop is gone. F those guys. I was dating a girl, showed up there, she was wasted, Nelson had his hand down her pants." And I replied, "I always told them to stay away from there. Some of them did. Some of them had to find out, well, it's supposed to say find out the hard way, but I had a typo. I feel sorry for those ladies."
And when is this document from?
This would have been from October 16th, 2018.
Can you flip to the next page?
Yes.
And do you recognize this document?
Yes.
What is this?
This is a declaration that Ryan Landworth filled out for the municipal court hearing. There's almost a municipal court hearing on Bainbridge for the TRO. Nelson,
And who is Ryan Landworth?
He is a blacksmith that lives on Bainbridge and a former member of the Bainbridge Fire Department.
And can you please read his letter?
Your Honor,
Yes.
same objection. It's hearsay.
Overruled.
Sometime around 2006, while I was a member of the Bainbridge Island Fire Department, I was invited to attend a party at the Chicken Coop Speakeasy. When I went, it was hosted by Bill Blakely and Bill Nelson. There were other members of the fire department and Bainbridge Police Department off duty that were attending. Shortly after arriving, it was revealed to me that they would be having a stripper that was still a Bainbridge High School student. I was not okay with any aspect of what was happening. I had a child that was a student at BHS. I thought the whole situation was very wrong and would not participate in any way, so I immediately left.
Can you go to the next page, please?
Yes.
Do you recognize this document?
Yes.
What is it?
It's an email Katie Fisher sent to me, and then later she also wrote a declaration for me for the court case, the Superior Court case.
Okay. And can you please read this email?
My name is Katie Fisher, and I met Bill Nelson at a bar in 2012, September, I believe. I've been drinking with friends at Isla Bonita, a bar on Bainbridge Island. I don't remember talking to him much, as he was older than my dad, a good 20 years older than me. After the bar, I remember very little, being in the car and him telling me he was taking me to his home. I remember being in his big master bath jacuzzi, and then brief memory of him on top of me. I came to enough to get a ride home immediately and shrugged the incident off as I was embarrassed. Now that I've heard it's happening to other women before, I'm questioning a lot more how and why I would agree to go home with a man my dad's age, etc. Anyhow, I hope I hope he stops.
Now, what is the date of this email?
December 9th, 2018.
Okay. And everything you just read, all the dates are after you had written the article on the Bainbridge Island.
Not the Jerry Roulette one. That was before I posted to. I made the Bainbridge Island bad list. The others were after. Yes.
Okay.
Or 1 sec. Yes, because actually it was after when I was in the Bainbridge Island Municipal Court.
But all of this information was told to you prior to you.
Yes.
And so this information that you just read was presented to you to help you with the temporary restraining order.
Yes.
Will you ask that one again, Ms. Lane?
I'm sorry, pardon me?
I missed exactly the question you asked. Would you ask that question again?
Yes, so all of the information that you just read, it was information that you had prior to writing the Bainbridge Island bad list article.
Yes.
And so the information that you just read from was given to you to help support your declaration in the temporary restraining order.
Yes, I believe the Katie Wiedemann one was to help me in the Superior Court. Or Katie Fisher, as her name is now.
Thank you. Going back to the video that Mr. Nelson took of you that is now posted on the internet.
Yes.
Is it posted to a specific website?
It's hosted on YouTube, but it's posted to lots of websites as a link from YouTube.
Okay. What is the name of the link on YouTube?
I don't know the exact name of it, but usually when Ryan posts it, it alludes to the fact that I was sweeping the restaurant at the time I was being served. And so it's usually something like 40-year-old loser sweeping restaurant could serve the lawsuit, things like that.
Okay. And did he create something called Houston Wade Lies?
Yes, it's a Reddit subpage, a subreddit.
And is that still up today?
It is.
And do you have anything to do with that?
No, that's all Richard Lee Renderson.
Were you allowed to make posts during the state court litigation?
I was.
Is that why you posted about the bankruptcy comments that you had testified to earlier?
Yes.
And is that why you posted about not paying a rapist shit?
Yes.
So when you say you're able to post during the lawsuit, do I take it that this TRO just expired at some point, it didn't get renewed or something?
The TRO was dismissed, and then the state court ruled there'd be no injunction on my free speech.
So there's a period during the lawsuit from the expiration of the TRO until the ultimate judgment?
Yeah. Yes, sir. Yes.
Go ahead, Ms. Lane.
Thank you. So I want to move on to that bankruptcy comment about Mr. Nelson. How did you bankrupt him?
I was not ultimately responsible for bankrupting him, no.
So then why did you post that?
Bravado, or thinking that I had some small part in it.
And what was that small part?
The fact that I had been approached by Katie Wynio and asked about Bill Nelson, and I told her everything I knew.
Okay, and then you testified earlier, you read from the deposition that eventually Mr. Nelson was denied a loan by Ms. Wynio.
He was, yes.
Do you know the parameters that Ms. Wynio used at her bank to approve or disapprove a loan for Mr. Nelson?
I do not.
And earlier, Mrs. Savagny asked if you wanted Mr. Nelson punished, and you said you wanted him charged, correct?
Yes.
And what do you mean by you wanted him charged?
I would hope that our legal justice system would work in a way that men who hurt women and children face legal consequences for these actions.
Okay. And then earlier you had also read from your October 2019 deposition. Strike that. Earlier you had testified that prior to your October 2019 deposition that you had told Mr. Nelson that he was going to be charged and opposing counsel was demanded $50,000. Why do you believe Mr. Nelson was going to be charged?
The woman I spoke to at the prosecutor's office and my conversations with the police investigator and the FBI investigator.
And do you know who you spoke with at the prosecutor's office?
I assumed it was Cassie Stokes.
And why did you assume that?
Because it was the phone number as a footer on her email.
And then one thing that actually was not asked you earlier today when we first took the stand is, where do you live?
Bainbridge Island, Washington.
And how long have you lived on Bainbridge Island?
My entire life, save for a few years in college.
And what do you do for a living?
I work at Bruciato, a restaurant. I'm also adjunct faculty at Edmonds College and the Seattle Film Institute, and I have a YouTube channel.
And how many classes on average do you teach a year?
About 3.
And then why did you start the YouTube channel?
During the pandemic, I had gone viral on Twitter with a thread that was explaining the GameStop stock squeeze, kind of in layman's terms. And I was asked to be interviewed by a gentleman in Northern Ireland who had a podcast to sort of go over that Twitter thread again. And that went super viral. And I was invited to a couple more podcasts, which also went viral. And somebody ultimately, who enjoyed hearing me talk, asked me to make my own YouTube channel. So I did. And it was a great way to connect with people when locked at home during COVID and allowed me to discuss topics that interest me.
Okay, so the videos that went viral, they were on topics that you have knowledge about.
Yes.
And what is the name of your YouTube channel?
Houston, we have a problem.
And do you have a mission statement for that channel?
Yes, it's more of a question that I answer. I ask, did we create society to make everyone's lives better, or did we create society to maximize profit and drive revenue? I believe in the former.
And what was your purpose to start the YouTube channel?
Originally, it was sort of to identify problems in society and then address ways we can fix those problems, things like healthcare or criminal justice or mental health, things like that.
Okay, what makes you think you have the answer to society's problems?
It's not so much that I think I have the answer any more than anyone else does, but it's a way that we can sort of flush out the problems, the systemic ones, and sort of the, I guess you'd say the symptoms of them and how we can fix them.
So why does your answer matter?
Sometimes I have an answer, and sometimes it's a great way to, and someone else might have one, and we can discuss it.
So what brings you here today sitting on the stand?
Ultimately, the lawsuit Bill Nelson brought against me in Superior Court.
Did anybody else sue you?
Yes,
And who was that?
John DeWars.
And what happened in that case?
Originally, he filed a temporary restraining order, same as Bill Nelson, in the Bainbridge Island Municipal Court. And at that hearing, his restraining order was denied. And then 2 years later, he sued me for defamation in Kitsap County Superior Court, and that case was dismissed, and I signed a confidential settlement agreement.
Can you walk me through how the Bainbridge Island bad list came about?
Well, in September, October 2018 was when the Brett Kavanaugh hearing was happening in the Senate, and Christine Blasey Ford was being criticized for coming forward 35 years after the fact from when she claimed Brett Kavanaugh had assaulted her. And people were asking, well, why'd she wait so long, et cetera. And I had an example of an incident I knew about where a woman escaped her rapist, ran next door to the neighbors. They helped her, called the police. When the police came, they chatted with her rapist, and then nothing ever happened. And I wanted to demonstrate that it doesn't matter if you wait 35 years or if you report it the moment it happens. Oftentimes, the criminal justice system will fail you. Under that post I made, numerous women were responding that similar instances had happened to them. They had similar awful experiences with the criminal justice system and seeking justice. Ultimately, people asked who the man I was talking about, and I said it was Bill Nelson. And from that point forward, people then started talking about their own experiences with Bill Nelson, how terrible he is, and it led from there. Such as, then I got messages like from Jerry Roulette confirming incidents as well. That is juxtaposed with another incident that happened on Bainbridge around the same time, where a man assaulted a teenager at a coffee bar, and there were comments happening on community pages on Facebook. And ultimately, I decided enough's enough. Like, we can't keep quiet about this stuff. And so I created the Bainbridge Island Bad List to warn everyone about these men who get away with these things in our community.
And did you yourself actually experience, and did you, I'm sorry, strike that. Did you yourself see Mr. Nelson doing anything that you posted about?
Yes. When I was a child, I lived in the Olympian condominiums, and Ginger Larson, who became Nelson's wife, lived upstairs with her children from us, and his daughter Audrey was my best friend. When Nelson started dating Ginger, my mom said I was no longer allowed to go to Audrey's house anymore. That she was allowed to come to our house, but I couldn't go over there anymore, and that was due to abuse that Audrey and her family were experiencing. Later, when I was in high school, I was at a party after the Tolo dance, and at a house party, and Mr. Nelson arrived with cocaine and tried to force himself on an unconscious girl who was asleep on a couch when myself and other boys who were in attendance forced him out of there.
Thank you. And did you create a mission statement for the Bainbridge Island Bad List?
I did.
What was that mission statement?
It was, here at the Bainbridge Island Bad List, our goal is to let you know who the worst of our neighbors are. We think you should know who the rapists, abusers, and creeps are so that you can protect yourself and your loved ones with knowledge.
Thank you. Can you please turn to Exhibit D6? And this has already been submitted into evidence. This is the answer that you wrote to the complaint in Kitsap Superior Court, correct?
Yes.
And this is the answer, more specifically, to the complaint that Mr. Nelson filed against you.
Yes.
If you can be looking on D6, page 1, we're looking at line number 26, the last sentence to that paragraph.
Okay. Mr. Wade alleges that Mr. Nelson does not have enough positive regard in the community for his character to be defamed.
Okay, thank you. 1 second.
No.
Can you turn to D6, page 2? And we're looking at line number 25.
Okay.
Can you read that last sentence?
Mr. Wade alleges that the comments made under his post about Mr. Nelson confirms the already existing negative opinion of Mr. Nelson by the community. And many of the comments confirm Mr. Nelson's predilection for underage girls, drinking to excess, and repeated sexual assault.
And can you turn to D6, page 3? And starting the first sentence of the very first paragraph on that page, starting on
Answering the allegations of paragraph 7 of the complaint herein, Mr. Wade denies that he has encouraged others to be vindictive towards Mr. Nelson. Mr. Wade alleges that he, oh, sorry.
I just wanted to read
Oh,
it.
okay.
D6, page 4, line number 25, that last sentence.
Mr. Wade alleges that a large portion of the population of Bainbridge Island already hold Mr. Nelson's reputation in an overwhelmingly negative light, and Mr. Nelson does not have a good name to tarnish.
D6, number 5. Looking at line number 5, that the sentence that starts on line number 5 and it ends on line number 8.
Okay. Mr. Wade denies any damage to Mr. Nelson's reputation is the fault of Mr. Wade. Mr. Wade alleges that any negative reputation of consequence Mr. Nelson encounters is due to Mr. Nelson's predatory behavior and overuse of drugs and alcohol.
Thank you. And just 1 second.
Let me see.
That is it. Thank you.
All right, go ahead.
Thank you, Your Honor. Mr. Wade, can you turn to Exhibit 2, subsection Exhibit D?
Is that plaintiff's exhibit?
Plaintiff, yes.
Which letter? To what?
2.
Letter.
Plaintiff's Exhibit 2, subsection D. Is dog. This was the first post that you made about Mr. Nelson, correct?
Yes.
And this was prior to October 16th, correct?
It was. I believe it was October 4th. The date's not on here.
October 4th. Okay. And you said you were served with the TRO when?
That would have been October 24th.
So turning back to Defendant's Exhibit D7. Going to page 11.
Yes.
That, you're alleging, is a response after the post that we've just referred to in Plaintiff's Exhibit 2.
Yes.
Okay. Similarly, if we turn to page 10 of D7, so the page before,
Yep.
that's dated November 8th.
Yes.
Okay? And page 12, that letter is dated November 30th.
Yes.
And the email on page 13, that's dated December.
1 second, let me catch up with you.
Sure.
I missed the last one.
I'll repeat that for the court, Your Honor. So
I got page 11, page 10, and then where did you go after that?
then we went to page 12.
Page 12.
And that letter is dated November 30th
The one on
on
Yeah,
page
page
12.
12, yes, yes.
And then moving on to page 13, that email is dated December 9th.
Yes.
Correct.
Yes.
And none of these documents in Exhibit D7 on page 10, 11, 12, or 13, none of them are signed under penalty of perjury, correct?
They're not, but Katie Weedman did fill out a declaration for the case later.
But this email is not correct.
No.
And in fact, aside from page 11, every single one of these was sent after you had been sent the TRO, correct? Correct.
No. Because Jerry Willett sent his before.
Which one's Jerry Willett?
The one on 11, yeah, sorry, 11.
Yeah, I said besides
That's
11.
right. Sorry.
So besides 11, so page 10, 12, and 13, all of those were sent to you after the TRO.
Yes.
And all of them were sent, in fact, because of the TRO, because of litigation.
Yes.
So at the time of your first post about Mr. Nelson, none of these corroborating claims that you're pointing to were in your possession.
Well, I mean, Ashley Cross DeGrow had commented on the posts corroborating that.
But obviously, your post came first, and then a response came afterwards, correct?
Yes, because I'd asked some of them to send me something.
So at the time of the post, you didn't have these supposed stories from individuals.
Oh, I had the stories, just not in a written form.
Going back to Exhibit 2,
Plaintiff or defendant?
I'm sorry, what?
Which plaintiffs or defendants?
Plaintiffs. And then Exhibit D within that In this post, you state that years ago, a connected alcoholic Republican politician / real estate developer raped my friend's daughter in Fort Worth. She escaped and ran naked to the door of the neighbors, who happened to be another friend of mine, screaming for help. They took her in and called the police. When the cops arrived, they shook hands with the rapist and joked with him for some time and then left. No arrests, no charges, no taking the victim for a medical exam or rape kit, nothing. You did not observe this, correct?
I did not observe it, no.
And none of the posts or letters that you received are from a witness of this?
No.
And this claim was ruled defamation by Judge Hauser, correct?
Yes, it was.
Okay, I'm sorry, could you go back to your immediate prior question? Basically two back, not the one you just asked.
None of the responsive posts or letters were from witnesses of this
Of that
allegation.
action. And how did you answer?
No.
Okay. You go ahead.
Moving to the second page, so just the following page.
Yes.
This is the post that you identified Mr. Nelson, correct?
It's the comments, yes. I identified Mr. Nelson, and yes.
And this is where you stated, I worked hard to bankrupt him and finally did, correct?
Yes.
Now, you've claimed that that's bravado speaking.
Yes.
So is that your way of saying that you lied?
No. Embellished, maybe.
Embellished.
Yeah.
So you didn't, in fact, bankrupt him?
I wasn't the one who bankrupted him, no.
No, but you said you did.
Well, it's subjective in the phrasing I use. Maybe hubris.
And going back to the first page, still on Exhibit D, the woman you're referring to that supposedly was raped, who was that?
That's Elizabeth Kaltwriter.
And you never posted, either here or in any of your follow-up posts, that in fact Mr. Nelson had to get a restraining order against her, did you?
I did not post that, no. I never found a restraining order against her.
Did you look?
I did.
Objection relevance?
Yeah, I think it's relevant, overruled.
Yeah.
So you looked, but you couldn't find it?
Yes, I looked, I couldn't find it.
But you were able to find records regarding Mr. Nelson?
Yes.
Would you say you're good at research?
I'm adequate.
You're adequate.
I don't know how to search for everything, but I can find some things.
Okay.
Could you just repeat who that woman's last name is we're talking
Oh,
about?
Kaltwriter.
Cult?
Yes, Kaltreider.
Thank you. Yep.
And did you ever do any research to see if Mr. Nelson had ever been arrested or charged with any type of sexual assault case?
I did search as well, yes.
And
and he had not been arrested or charged.
No. And did you tell that to your followers as well?
No, the entire point of the article was to point out where the criminal justice system has failed us.
Did you look to see if anyone had filed a rape complaint against him?
No, it did not.
No, you didn't. And did you look to see if anyone had sued Mr. Nelson for rape or sexual assault?
I did not find anything on it either, no.
No. And so did you tell your followers about that as well?
No.
No further questions, Your Honor.
Ms. Lane, any further questions for this witness?
Yes, I do.
Okay, just 1 second, please. All right, go ahead when you're ready.
Just 1 second, Your Honor.
Yeah.
Your Honor, while we're waiting for counsel, can we have a bathroom break after the conclusion of Mr. Wade?
Yes.
Thank you.
So wait, how did you know of the alleged rape?
Troy Dentman told me all about it.
Who's Troy Dentman?
He was the neighbor that Elizabeth Cutwater had ran into for help. And he was my roommate for a period of time.
Sorry, again, I'm not good at catching these names.
Oh, Troy Detman.
Detman. All right, thank you.
Dettman.
And how
And
was
then-
it?
Whoops.
Sorry.
Oh, sorry.
I'm still just trying to make sure I got your answer.
Yeah.
So you heard about it from him, and
Yes.
then what was your relationship with
He,
him? Or?
he was the person Elizabeth Cutwater had run to for help, and he was my roommate for a period of time.
So you're saying she ran to his house or
Yes.
his parents' house?
Well, his and his wife's house at the time.
Go ahead, thank you.
When was this told to you?
This would have been probably around 2011 or so.
How was it disclosed that it was Elizabeth Cultridge was the alleged victim of the rape?
A cult writer.
Sorry.
Troy named her, and then later her.
Object, this is hearsay, Your Honor. I can tell they're trying to craft their questions in such a manner to get around it, but this is an out-of-court statement.
So it still goes to Mr. Wade's state of mind.
Yeah, I agree. I still agree with that. I mean, I'll overrule it. I don't think the truth of these things really matter when we're dealing with subjective intent, so I'll let you ask the question.
Okay.
Did you ever use Elizabeth's name in any of the posts?
I'm not in the post now.
So how did her name become known as the alleged victim?
In the original TRO, Mr. Nelson named her.
So you did not name her?
I did not name her, no.
All right, thank you. That's it for.
Any further questions?
Very quickly, Your Honor.
Sure.
Who was the individual again that allegedly told you this story?
Well, two people did. First one was Troy Dentman.
Troy Dentman.
Yes.
And he didn't submit a declaration in the underlying case, did he?
He didn't have a chance, no.
No, he didn't. Didn't have a chance?
Yeah.
Okay. But litigation was going on for how many months?
Sometime, yes.
Sometime, okay.
I was hoping to depose him.
Sure. And on the post in Exhibit D, plaintiff Exhibit 2, subsection D is in dog.
Yes.
No, it said subsection D.
In that post, so second paragraph, you said years later in the middle of the night, she phoned her 13-year-old son and said her goodbyes and then jumped from the Agate Pass Bridge.
Yes.
That's a pretty detailed note about the individual.
Yes.
So there was not any confusion as to who you're referring to, was there?
If you knew the situation, you'd probably know exactly who I was talking about.
Nothing further.
Ms. Lane, anything further?
No, Your Honor.
All right, Mr. Wade, you can step down. Thank you. So we'll take a break in just a second, but tell me where we go from here. Are you going to recall Mr. Nelson? Does either party want to recall Mr. Nelson?
Smith, can we?
Yep, go ahead.
Thank you. We will not be recalling him, Your Honor.
All right, Mr. Savaggi?
No, Your Honor.
All right, so anyone have any other evidence they want to put in, or are we just down to closing arguments? Just closing?
I think closing, Your Honor.
Ms. Lane, just closing?
Closing.
All right, then let me give you a little bit of time, and we have time, so why don't I work off of you? How long of a break would you like to gather your thoughts and put together your closing?
Your Honor, if you can have 30 minutes.
That's fine.
All right, so I've got 2:25. Why don't I give you 35 minutes? We'll do closing at 3 o'clock. Sure. All right, be at recess. Thank you.
All rise. All rise.
Please have a seat. Thank you. All right, closing, plaintiffs.
Thank you, Your Honor. Again, Paul Frazier for the record. Represent the plaintiff, Mr. William Nelson. I think it's important to remember that a discharge in bankruptcy is a privilege and not a right. And it should only inure to the benefit of an honest debtor. And what we have here is a dishonest debtor. Mr. Wade has admitted under oath that he lied under oath. And the Kitsap County Superior Court determined in its order that Mr. Wade lied under oath. We only need to show that by a preponderance of the evidence, meaning that it's more probable than not, that Mr. Wade must have actually known when making these statements that injury was substantially certain to occur. We don't need to establish or get an unqualified admission from Mr. Wade. If that was the case, then it would be nearly impossible to accept a debt from discharge. The willfulness element is satisfied when the natural consequences of the debtor's actions are substantially certain to cause injury. And there is a presumption that the debtor knows the natural consequences of his actions. We have already established as a matter of law that the statements that were published online by Mr. Wade were false. We have established that they were malicious. We have established that they caused injury. So we only need to establish, again, by a preponderance of the evidence, that when those statements were made online repeatedly, that Mr. Wade should have known that they were substantially certain to cause injury. And again, they've already been determined to be false. It would be nearly impossible for any reasonable human to believe that false allegations of sexual assault made online would not be substantially certain to cause injury, or would not be likely to cause injury. And while the story testified to in court today by Mr. Wade is that he was trying to protect the community and to report claimed bad actors on Bainbridge Island, that story just doesn't hold water. Mr. Wade testified under oath that he intended to cause Mr. Nelson's bankruptcy, and in fact testified that, and in fact bragged that he caused Mr. Nelson's bankruptcy. So this had nothing to do with protecting the community. This was a targeted attack to cause and inflict as much, reputational and financial harm as Mr. Wade could possibly inflict through publishing these false allegations on social media. Now, significantly, there was not a single witness or sworn statement, under oath presented by Mr. Wade to corroborate anything that he has said. Not one. Mr. Wade did not attempt to introduce into evidence any sworn testimony by any independent witness. There was not a single exhibit admitted into evidence by Mr. Wade attempting to support the truth of the allegations that he made. All we have are hearsay, out-of-court statements, not sworn under the penalty of perjury, and there are reasons we have, rules of evidence. There's no one here to back up anything that's been said. Mr. Wade himself admitted that he did not find any corroborating evidence to support the allegations that he made. He claims that, he says he is he is a proficient researcher online. He did not locate any criminal proceedings, any civil proceedings supporting his allegations of rape, yet he states that as fact over and over and over again online. What this was this was a social media lynch mob designed to destroy and defame Mr. Nelson. And none of that lynch mob has never stood behind anything they've said. They had, this has been in litigation for 5 years, since 2018. And if there was anyone to corroborate, again, any of these statements about Mr. Nelson, they had 5 years to come forward with a sworn declaration. Mr. Wade had the opportunity to depose them or to have them testify in court in his favor. And it's been 5 years of complete and utter silence. Mr. Wade admitted through requests for admissions that he made all of these statements that have been alleged. Plaintiff's exhibits number 2 and 3 were admitted into evidence, and specifically Exhibit B, Exhibit C, Exhibit F, and Exhibit H. Mr. Wade admitted to posting online. So there is no question that this stuff and these defamatory remarks were made. They've been introduced into evidence. He does not dispute making them. And similarly, he does not dispute the damage that they caused. Again, Mr. Wade concedes and admits that he was targeting Mr. Nelson, that he loathes Mr. Nelson, that he hates Mr. Nelson, and that he was purposefully intending to injure Mr. Nelson. There is no dispute about that. And this is all stemming from, and I'll quote the Superior Court, wild allegations that have no basis in reality. So when you make wild allegations that have no basis in reality online repeatedly about falsely accusing someone of sexual assault, it's more probable than not that that is substantially certain to cause injury. And again, there's no dispute that these allegations were made. There's no dispute that Mr. Wade made them. And even in his deposition, he talked about karma and about karma being part of the universe, coming back to, exact retribution and pay people back for, alleged wrongdoings. And Mr. Wade, he believes he is the universe. That's what he stated in his deposition. I mean, his Twitter handle is Rock God, and he stated that he thinks he has the answers to cure all of society's ills. So he himself believes that he is like a god, essentially. He is out here to exact punishment on individuals who he himself believes should be punished, and that's what he was attempting to do here. This was not about the community. If this was about the community, these would have been objective facts supported by actual evidence, not wholly uncorroborated, again, wild allegations that have no basis in reality. And I think we've probably all read the news enough to know that wild allegations of sexual assault that have no basis in reality actually do more harm than good. They don't help the community. In fact, all they do is tend to undermine what actual victims of sexual assault are trying to accomplish, which is to have someone believe them. So any claim that Mr. Wade was attempting to, help the community is just simply not true. And it cannot be true as a matter of law based on the findings in fact and conclusions of law in the Superior Court judgment. So again, the low burden of proof here is a preponderance of the evidence. It's whether or not the debtors actually knew that injury was substantially certain to occur. And it is more probable than not that wild allegations of sexual assault having no basis in reality, repeatedly published on social media, would tend to cause or would be substantially certain to cause injury. And for that reason, Your Honor, we ask that Your Honor find that this debt be accepted from discharge for willful and malicious injury.
All right, very well, thank you.
Thank you, Your Honor.
All right, defendants.
Thank you. I need to move my computer, it will die on me.
Blessing and the curse of technology.
Yeah. It's all right, we'll work it out.
Wade can't support any attack on the facts because the very order that they have argued successfully is intact. This court has made that clear. But now we are here to discuss one little prong of 523A6, the willfulness prong. Here are the facts. Mr. Wade testified that Mr. Nelson personally took video of a process server serving Mr. Wade, and Mr. Reinerson got the video. But under oath, Nelson said he doesn't have any meaningful relationship with Mr. Reinerson except for encouraging emails. Nelson said Wade made these accusations out of thin air. But Nelson testified he was charged with 4 DUIs, including a hit and run, and his ex-wife filed a domestic violence restraining order and made specific allegations of violence and threats against Mr. Nelson. This is all public record and it happened prior to the Bainbridge Island bad list. He also testified his 4th DUI was in 2018. Mr. Wade testified he witnessed a sexual assault by Mr. Nelson years prior to the Bainbridge Island bad list being created, and this is unrefuted. Mr. Nelson admitted the use of cocaine. Let's remember he supposedly doesn't remember which substance he was under when charged with his first 2 DUIs. When Ms. Hulsman asked if he was ever arrested for assault, Nelson said he couldn't recollect. While I'm pointing out problems with the truth Mr. Nelson had on the stand, we're here today to determine Mr. Wade's subjective intent. A dishonest debtor relates to a debtor that has lied on their schedules. Wade is not a dishonest debtor. The basis for Mr. Wade's beliefs are substantiated here. Nelson testified that some of the negative comments on the October 4th post, which is Defendant's Exhibit 2, were people he knows. The only evidence the plaintiff has submitted is their Exhibit P1, the findings and facts and conclusions of law that Wade's intent was to run Nelson off the island. Nelson testified he is still living on Bainbridge Island and still has his business there. Nelson also testified that he was scared to go in public after the Bainbridge Island post. However, he went out in public and filmed Mr. Wade on October 25th, and this is unrefuted, and submitted that video to Mr. Reinerson to post for him. However, Nelson acted on the stand that he barely knew Mr. Reinerson. Nowhere did Wade say he published the statements with the intent to harm Nelson. Wade has maintained through the state court in this action his intent was to protect the community. This is reiterated in Wade's answer to the state court complaint. This is Exhibit D6. This is in line with the mission statement for the Bainbridge Island Bad List that Wade testified to on the stand: to protect yourself and your loved ones with knowledge. Nelson's reputation is a -1. This again is unrefuted. His reputation did not become negative because of Wade's comments. It's quite the opposite. Many people in the community already had a negative view of Nelson prior to any of the posts Wade made. Putting it simply, Your Honor, the plaintiffs have not met their burden. Thank you.
Thank you. All right, so that will conclude the trial. Record is closed. And so I just need to check with your schedules and set a time to rule. It can all be telephonic because I'll be the only one talking that day, but your clients are welcome to call in addition to the lawyers. And so let's find a time in the not too distant future to do this. I need a little bit of time to prepare. How would September 29th work for the parties? Either at 11:30 or in the afternoon?
11:30 works really well for me after daughter's nap time.
All right.
Looks right. I'm probably going to end up being in the hearing on that day. Okay. So if you're available. Yeah.
As long as at least one of you.
Yes.
I need at least one of you.
I think
11:30 works fine.
I think I'm going to be in the hearing, but
All right, let's do that.
Frederick will be available.
You know, and it'll eventually be on the docket, probably by the end of the day, if you want to go back and listen to it.
Will do.
So let's set, oral ruling on the trial will be set for September 29th at 11:30. My guess is it won't take in no more than 30 minutes probably, just for your planning purposes. If for any reason I'm not ready to go, I'll have my chambers give you a call a couple days ahead of time and we'll reschedule, but I fully anticipate that I will be ready to rule. So we will enter a docket entry indicating that the court will issue its ruling September 29th at 11:30. And just a day or two before, if you want to call chambers to make sure you have the current proper phone information. We do change the passcode pretty often. And with that, we'll wrap up today. I want to thank everyone. I thought everyone acted professionally in what can be a stressful environment, particularly considering the subject matter of some of the testimony today. So I appreciate that from everyone. And now we will be at recess. Thank you.
All rise.